All right, this is case number 23CV0208, Daryl Michelle Rogers versus Daryl Bailey and Kimberly Hazard. The plaintiffs were present represented by Attorney John Ford, and the defendants are each appearing without counsel. Is that correct, Mr. Bailey?
That's right.
Ms. Hazard? You don't have counsel either?
Pardon?
You don't have counsel?
No.
Okay. All right. Now, this matter was set for trial, and we did have a pre-trial a few days ago, a couple weeks ago, I think. And I noted that the trial will be proceeding on the question of the specific performance requests have been dismissed or withdrawn, and you're going to proceed on the breach of the contract for damages, right, Mr. Ford?
Your Honor, I did receive some documents regarding and their argument on Saturday.
Well, wait a minute. My question was this. I'm asking you about your pretrial statement. Your pretrial statement, we talked about that last week, said you were withdrawing your request for specific performance.
Yeah, we would only go forward on count two.
On count two, yes, and that's the reason I brought that up, because I think there was I read it the way you said, but I think there is a Scrivener's error in your brief, because you say, under A, you say on page 2, they would no dismiss their first and second claims and seek damages caused by the failure to comply. I believe what that means is you would now dismiss your first and third claim. The third claim is fraud.
Right.
First claim is specific performance. And I've granted judgment on count 2, breach of contract.
Yeah.
So that's the only thing you're proceeding on.
Yeah, that's what we would
Okay.
do, Your Honor. I
Right,
was going to,
okay.
in
All
my
right.
opening statement, I was going to run over
Okay,
that.
so I just need to make my notes to put that into the order that count 1's withdrawn, count 1 and 3 withdrawn. All right. Okay, so we are here then solely on the issue of damages on the breach of contract. The court has already ruled that the defendants breached the contract. So the sole issue in the trial then will be for damages. Mr. Bailey?
Yes, sir. The plaintiffs never had any legal rights to.
Well, that ship has sailed, because they filed a motion for a summary judgment, and you didn't file an appropriate brief that contested that. I went through it and I filed a decision that said that that you're in breach. So that issue you cannot litigate. We're not here to litigate that.
Okay.
You lost your right to litigate that. Well, you lost the issue when I ruled in favor of the plaintiff for summary judgment, because you did not present any evidence that's permissible under the rule or in a matter that would allow the court to consider it. So that's,
I understand.
you're out of, you're, okay? All right, thank you. All right, so with that, then I will hear any opening statements if you wish to make any, Mr. Ford. If you wish to make any opening statement on your...
Yeah, this is very short.
Go ahead, then.
Your Honor, let me just begin sort of to backtrack what I was going to say. We originally, parties entered into a contract on June 26th, I believe, 2023. The contract was, the last date for the contract was on September 30th, 2023. There's an issue that I will go over about the last requests from the VA. You have, and because of that, the defendants refused to continue this one day in order to complete comply with the request from the VA. I'll go over that in just a minute. So there was no, the contract fell through, and we alleged 3 claims, but the second one was a breach of contract. We included that in our motion for summary judgment, and that was supported by, in addition to the evidence that, the affidavit evidence that was provided by the verified complaint signed by Daryl Rogers. Michelle Rogers, his wife, submitted an affidavit. We also had 2 other people. We had Lisa Pratt, who was the realtor for the buyers, and then we also had the well, he's out of Atlanta. He was the person working the VA loan. He would have been the I don't know, the lender's agent or somebody working on his behalf. What we provided that information, and based on that, you found that there was a breach of the contract by a failure to comply with paragraph 17 of the contract, which states that you have to comply with the, follow any of the inspections or appraisers allowed by the VA. And that was what did not occur. There was clear evidence that that didn't occur. This court found that that evidence was caused a violation of breach of contract. Although there was nothing indicated on the right before the end. We provided this evidence from Mr. Cost, but this is going to be an issue here, and I have Ms. Pratt here to testify to verify this. After this court found and agreed that there was an engineering, the VA required an engineering inspection, and they did do that, and it found a defect in the engineering. So first, this was issued, the report from the engineering firm, which I think was Hyman Engineering, was on the 15th of September 2023. So that would have been just 15 days before closing. And what happened at that time is, first of all, they tried to see if they could work out a settlement of that between the parties. The sellers refused, which they had the right to do. But
Mr. Ford, I'm not hearing anything about damages. You know, what you're talking about, I'm very familiar with.
Yes,
I've
yes.
already ruled on all that.
Yes, but no, there's something he didn't rule on, and that's what I'm trying to
Okay,
get.
well, let's get to the point, because the point of this hearing is damages.
Right, and what we would allege here is that on the, you said there was a question, you said in your motion there was a question, or in your order, that there was a question of whether or not these damages, the failure to comply with Rule 17 caused the delay. Okay, and that's what I'm addressing right here.
Okay.
Okay, what in fact happened was when this engineering firm went forward, and my clients had to change to a different kind of loan. They had to change to a renovation loan, not a standard loan like they had already had approved. The renovation loan went through, and they got approval for that on the 28th of September. So that would have been just 2 days before the closing. At that time, they received a notice from the VA, and it was at about 4 o'clock in the afternoon saying, we have everything we need, we'll verify the loan, but we need to have the certification from the engineering firm of their background. Now, in order to get that, that had to be sent by overnight mail from the engineering firm to the VA. And so on the 29th, which would have been a Friday, they sent that out. But because it had to be sent by overnight mail, it could not appear, it would not be received by the VA until the following business day, which was October 2nd. So and Ms. Pratt can testify to this, they contacted the clients and they said, look, we need additional time, additional 1 day in order to get the certification to complete the loan. And that's required by the VA, and the sellers refused to do that. They refused to extend it 1 day from which would have been Saturday the 30th to Monday the 1st. And based upon their refusal to comply with the request from the VA, which is set forth in paragraph 17, we think the entire contract is an issue. Now, what we will do now is we will also have Ms. Rogers testify as to the damage that they have incurred. Now, what happened once the contract couldn't come through? They had to be out of their house within a month. So they had to move into a rental home. They had to move all their belongings temporarily into storage units. They had to pay additional costs and fees for the apartment that they rented, and they had to look for another house because they no longer had any place permanent to stay. And that took them a number of months, but they eventually found another house, which is why we have no issue with a specific performance contract. And, she has put forward, and we put forward the specific documents that we had in our trial brief. You'll see that the rent was $600 a month for 8 months. So there would be that amount. There would be the amount of the storage unit, also the utilities that were paid, the heat and electric. We have all those itemized. The total amount, and then in addition, the search for the new house and a it took them 8 months or something to find the new house, and the costs incurred in that, which they estimate, and Ms. Rogers will explain, was $10,000. So when you add all that up, we come to a total amount of damages that we're asserting of $23,138.40. And that's what we will presenting evidence for. So those are the issues that we're going to raise here.
All right, thank you.
And I would also like to add, by the way, the documents that I've gotten that the plaintiffs have, the defendants provided me for their arguments, we believe have all been waived by failure to comply and raise an affirmative defense in the answer, and also to respond to our motion for summary judgment. So just putting that forward as well.
All right, now, Mr. Bailey, you wish to make an opening statement on your behalf?
Yes, I do. The plaintiffs had 4 extensions in this contract. Kim and I granted the 4 extensions. We didn't really legally have to grant that many. We were cooperating with the plaintiffs on the sale of this house. Now, he says somehow we got a notice on a 2-day extension. That didn't happen. What they did on September the 30th, asked us for another.
Well, let me explain something. I'm not really interested in that. I've already ruled there's a breach, as I told him. The issue here is how much damages can be proved. So you need to address your comments to that.
Sorry, Your Honor, I was headed in the wrong direction. On just the storage, they want to charge us storage for September, when this contract still, they had to move, so they rented this storage, and they're charging us before the contract, before they ever found out. Had we granted this extension, and had they moved in our house, they wouldn't have had to rent September. And actually, in their receipts on this, they charged September twice. Now, as far as the electric goes, Your Honor, you're going to have to pay electric no matter where you move. It's not fair for them to charge us an electric bill when they're going to have to pay an electric bill no matter where they live. And they have charged us an electric bill the same twice. And none of this is notarized. No receipts actually from the electric company. No real receipts from the storage. It's all computer. A lot of it's ineligible where you can't really read it. And as far as, see, we got the moving. They were going to have to pay for the moving anyway. And they actually paid the movers, I guess, while this contract was still going on. And as far as the rent on this house, if I'm not mistaken, they moved in this house in December. And they say they just recently bought it, and we don't know what recent is. We need proof of when they bought this house, because they're paying on the same house that they live in now. And on the rental contract, it says no deposit, which is kind of fishy. Usually if you rent some month or 2 deposit down, it says on the contract what the late fees are if you're late for rent. That's nothing. So this whole contract deal of us renting our house that we ended up buying by coincidence just right before we come to trial, so we can back charge from December to now on rent, just doesn't ring true. And none of this is notarized. That is pretty much my statement, Your Honor.
All right, thank you. Ms. Hazard, do you wish to make any opening statement on your behalf?
Yes, I do, Your Honor. First off, they act like they wanted an extra extension. We've never received it.
Right.
And according to the contract, they have until October the 7th. If they could close by the 2nd, why didn't they? You know, why didn't they? They had until the 7th. You can read the contract. They get 7 extra days because it wasn't our fault or their fault that the closing didn't happen. So if you look on page 8, 420 and 421 of the contract, it tells you plainly that it's till October the 7th. Now, they already knew they were moving and having a place on September the 13th. If you look at their papers, September the 13th is when they're starting, they're moving on September the 13th. We have not even had a foundation inspection then. We ain't even got our inspection from the foundation to find out it's failed, and here they know they're moving on September the 13th. This is all their paperwork I'm going by, okay? It's just according, and this is their contract they made. And their bills that they're sitting here acting like, well, they can't, if you take a calculator, they can't even calculate the numbers correctly. And they have the March and February on there twice just to bring it up to 20, what? They wanted 27, I believe it was. They wanted to be 2701 or something. Well, even if you add in the 2 wrong months, it's 2705. But if you take them out, it's only 1933, which I never seen bills like this. Okay, bill, my bill comes with my address, my name, my address, the wattage you use. I mean, it's, I imagine you've got an electric bill. Everybody knows what one looks like. I'm questioning the bill, but I definitely am stating that they're recharging on the bill, if you look at it. And it has, it's like they blanked out 20 what? You see it's blanked out. 2021, 2022, 2023, what year is it? It's not stated. Well, our bills come with dates. It says it's from this date to this date, but you're charged this much wattage. I mean, that's all I'm stating about that. And as far as the contract, they have until the 7th. I don't know why she didn't point it to them. Elizabeth Pratt could have pointed that out to them. But they failed to know their own contract, and it's not our contract. You know, we just went by the contract. And their pre-approval letter was for a different property, and they think they just take a marker and mark it out. Well, you can't. You have to, you know, put in an address there. What is this for? And the check. I mean, you have to state what this property is for. You can't say, oh, well, let's just
Ms.
mark
Adams,
it
you're getting
out.
away from the subject as well. We need to speak to the issue of damages, as I've already ruled that you're
Okay,
in breach.
I'm sorry.
Because I thought, you know, the procedure was that I had to decide it based on what the information was that submitted, and you didn't submit any of this information, so you can't submit it now.
All right, well, then that's pretty much what I got to say, except that, you know, I never did anything wrong. I did,
Objection,
let
Your
the
Honor, this is just
inspections
argument.
happen and everything.
Yeah, wait a minute. You're in the argument. An opening statement is simply for you to tell the court what you think the evidence is going to be, not to argue your position, so his objection is well taken. Okay?
Okay, but that's, according to the damages, that's what all I had to say was that they dealt with the electric bill. If you look on in the year,
Well,
not
keep in
even
mind,
date.
I haven't seen any of this information yet.
Okay,
Okay, so I'm not in a position to rule that they're going to have to prove their case. So that's why I say the issue is about what you think the evidence is going to be. If you think that they're not going to be able to prove their damages, then that's what you say, and then we find out if they can. I'm not going to rule based upon what he said or what she said. Okay?
Right.
All right?
Right.
It's going to be on whatever evidence I hear today. Okay?
Right.
All right.
right.
So if you would just make your remarks accordingly then.
That's pretty much it, just that
All right.
I figured they had till the 7th and what I thought about the bills.
All right, thank you. All right, Mr. Ford, your first witness.
Yeah, we would call Elizabeth Pratt.
All right, Elizabeth Pratt.
Yes.
Have you been sworn in the clerk's office? Would you raise your right hand, please? You solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Just have a seat over here, and I'll remind everybody to make sure your phones are turned off.
Over here.
Yeah, right there. Go ahead and have a seat. Now that light there on that, that's a microphone. If you would slide that toward the wall there, as far as it goes. There, you can speak into that when you're talking, or when you're testifying. All right, Mr. Ford, you may inquire.
Should I just stand here?
Yes, you may stand there.
Okay, thank you very much.
If you want a podium, we have one, but you can just do it from there.
Please?
I said, if you need a podium, we have a podium.
You know, I can stand here and do this. or
Okay,
sit.
that's fine.
Okay. First of all, Ms. Pratt, would you state your name for the record?
It's Elizabeth Pratt. However, I do business under my nickname Lisa.
Okay.
What?
Lisa.
Lisa, okay.
Okay.
2 E's, no I.
And where are you?
2 E's, no I, okay.
Yeah.
What was your relation to the Rogers?
They were my clients,
Okay, and they were your clients for what?
real estate.
Real estate.
I was their realtor.
Okay, and who was the real estate agency that you were working for?
At that time, it was Home Experts.
Okay, and when you've seen copies of this contract that's at issue, is that the agency you were working at when the
Yes, sir.
Okay, now, just generally, what was your involvement as the realtor in executing that contract? What did you do?
So the job of a realtor is to figure out what property suits your client's needs, which we saw many properties. We put in offers under a couple of them, which fell through to do inspections. It's my job to make sure that my client's best interests are taken into consideration. The property that they were originally approved for, it fell through due to inspections. I advised them not to go forward with it. Of course, they do have the right to go forward with whatever they want.
That's not the property at issue here.
No, it is not.
Tell me what happened, how did they enter into a contract for the property at issue here?
We went up and saw the property on Washburn in Hillsborough. They fell in love with it. We put in an offer. The offer was accepted.
Okay. How did the contract arise? What were the terms of the contract?
As far as
Did you draft the contract?
I did,
Okay. And you put in all the terms in the contract?
I did.
Okay. Can you tell me what is the provision in paragraph 17 of the contract? Let me, perhaps I can read it to you, it might be easy. It relates to
Now,
compliance.
Ms. Ford, I don't have an exhibit before me, so
Please?
I don't have any exhibit yet. You're asking her about something that's
Oh, I
not.
provided them to the courtroom, Your Honor.
Okay, do you have it?
Yeah, it's a
Wait a
30.
minute, I've got to get the exhibit, and you'll need to refer to the exhibit number.
Your Honor, I'll
I
tell you.
have the defendant's exhibits,
I'll
but
tell
not
you
the
the-
plaintiff's.
The contract was attached to the verified complainant's exhibit.
Well, yes, but it's going to have to be, I mean, that doesn't make a trial exhibit, as you know. So you say you provided the exhibits to the bailiff the other day?
Yeah, well, here, I can re-provide it, Your Honor.
So what exhibit is the contract? Okay. All right, we have it. I have those now.
Okay.
They
Your
were-
Honor, this attached to the verified complainant's exhibit A. And I think it was also referred to in the affidavit of Ms. Pratt.
Those are not trial exhibits. You're going to
Okay.
have to get them marked for purposes of this trial. I
Sure.
ruled on a summary judgment, and attaching an exhibit to the complaint doesn't make it a marked exhibit. This is a trial.
I had you an exhibit that, it was previously marked as Exhibit A, but we will mark this as Exhibit 4 for trial. or I'm sorry, Exhibit 4 for trial. Can you tell me what that document is?
That's a standard real estate contract for the state of Ohio.
Okay, and is that the real estate contract that you prepared?
It is.
Okay, and you prepared each of the elements of that contract?
I did.
Okay, can you read it, tell me what is in the provisions of paragraph 17 are?
Paragraph 17. Seller agrees to make the real estate available at reasonable hours for access by licensed real estate agents / brokers and buyer's inspectors, licensed appraisers, and other authorized parties as required in order to satisfy the terms of this contract. Seller shall have all utilities servicing the real estate on during the pendency of this contract. Buyer acknowledges that buyer is not authorized to be present on the real estate without a licensed real estate agent unless prior express written authorization is obtained from seller.
Okay, that's a standard contract term?
It is.
And this was a VA loan that was involved?
It is.
And the VA loan required certain inspections and appraisal? Did they require an inspection of the mechanical inspection of the building? Because it was prefabricated?
Correct, yes.
Okay, and do you know what was the result of that inspection? What was the report?
The engineering company that came out discovered that the foundation, the permanent foundation, as you said, it was a manufactured home. So in order to be considered real property, it has to be on its own land and has to have a permanent foundation. The engineering company found that the permanent foundation was not properly installed, therefore it did not pass the inspection.
Okay, what did you attempt to do to remedy that situation?
At that point, I contacted their real estate agent and asked for the sellers to pay for the repairs to the foundation, and they refused.
Okay, so what happened then after they refused to make any of those repairs?
I spoke with my clients and they agreed to paying for the foundation repairs to make it passable per the VA. In order to do that, however, the foundation would have had to either been repaired prior to closing or it would have had to be turned into a renovation loan.
Okay, so what did you end up doing?
I advised my client not to do any work to somebody else's property and suggested that they do look into the VA renovation loan, which they did.
Okay, and what happened in their application for a VA loan? A renovation loan?
It was approved, but the VA has very strict guidelines, so they needed a certification from the engineering company.
Okay, now when was it approved?
As far as the loan, the renovation loan,
Yeah,
I want to say it was the 28th,
okay.
27th or 28th
Of September 2023.
Correct.
Okay, and when was the closing date under the contract?
At that point, we had extended it to September 30th. We had multiple extensions, some due to the VA and others due to waiting on the defendants to allow the appraiser onto the property.
Okay, so the last date was what?
September 30th.
Okay, and that was a Saturday?
It was.
Okay, and you got the notification that you needed some additional information to comply with the VA loan on the 28th?
28th, yes, I believe that's correct.
Okay, so what happened then? What
I contacted the engineering company, told them what we needed. They said they'd send it out overnight.
Okay, so when would it be received?
Because of the late hour that I received the notification that I talked to the engineering company, they were not going to send it out until the following date, which would have been the 29th. It would not have arrived until that following Monday.
Which would have been what day?
I want to say October 2nd.
Okay, the closing date was on a Saturday?
Correct.
So it was September 30th was the closing date, and that was on a Saturday?
Correct.
And the next time, the next business day for receipt of the overnight mail would have been Monday,
Monday, which I believe was the
which would
2nd.
have been October 2nd. Okay, so what did you do, which was 2 days after closing?
Correct.
So what did you do to try and address that situation?
I actually wrote up an addendum requesting an extension through the 2nd so that we could close on the 2nd, mainly because that it had been such a complicated transaction. I wanted to make sure all bases were covered. So I did submit that. The defendants refused to sign.
Okay, and what happened from that?
They terminated the listing after that.
So when was the actual date of closing?
It was still set for September 30th.
Okay, and your extension was refused by the sellers?
Correct.
Okay, and the effect of not extending the closing date, what did that cause? What
Well,
was
number
the-
one, Mr. and Mrs. Rogers had to start all over,
Okay,
which meant I had to start over all over, and I'm fine with that. That's part of my job. They were just totally starting from square one again.
okay. Let
They
me
had
ask
to
you-
rent a property.
Let me ask you this. Was the extension required under paragraph 17 of the contract?
It was, because we had to secure the different kind of loan due to the,
Okay, when was the first time that the VA requested the certification of the engineering firm that had performed? Was it the 28th?
I believe it was like about 4:30 in the afternoon on the 28th. It might have been 3:30, don't quote me on the time.
So that was the first time the VA made a request?
That is correct.
Okay, and in order to comply with that request, you would have needed an extension until October 22nd? or
Until October 2nd, correct.
Okay, and and you contacted the seller's realtor,
I did.
and the sellers refused to grant that extension?
That is correct.
Okay, so that meant they refused to comply with paragraph 17 of the contract?
That is correct.
Okay. Your Honor, I don't have any more questions of Ms.
All right, Mr. Bailey, do you have any questions you would like to
Yes, I do.
ask? You may ask.
A little bit nervous here. I'm sure you are too. Ms. Pratt, you're a realtor and you handled the plaintiff's real estate contract. Is that right?
That's correct.
Okay. Now, standard procedure is you take your finances, go to the bank, get a pre-approval, come back, find a property, take that property back to the bank. They give you a list of items you need checked off before you ever go back and set a closing date. That's the way it works 90% of the time.
I'd say about 85%, but yes,
Well, we'll say 87, we'll split the difference.
that works.
So, why wasn't this real estate done in that procedure? Because there was a total of 5 extensions. The first extension, a couple weeks into it, I had second thoughts.
Objection, Your Honor. This is not an issue that's relevant here. The issue here is relevant is what happened in the final time when there was an extension already granted to the 30th.
But
Hold on, okay. Let me clear something up. I misspoke because I didn't read my summary judgment ruling as closely as I thought I had. But the ruling of the court is that whether the breach caused the damages and the delay of the closing on September 30th. So, that would be and any consequent damages after that. So
that's the point.
you need to ask questions, not argue.
Okay.
Okay, and you need to make them, you're asking a question
I see the
that
format.
hadn't been, I mean, you started
Yes.
about, don't interrupt me.
Okay.
You started and you were about 40 seconds into your question, so make them shorter and make
Okay.
them precise so that it's clear what what the issue is.
Your Honor, I have a copy of your ruling. Do you need a
No, I have it right here.
Oh, okay. I
Yeah.
didn't, I thought you said you didn't have
Yeah.
it, but I haven't, right now.
Yeah, because I recall now that the issue is that there was a breach, and the question was whether the earlier breach was the cause for the delay of the closing on September 3rd.
Okay.
And so that, her testimony is appropriate for that. And he can ask questions about that. Right now, she doesn't have anything to do with damage. Well, I won't say that precisely. Go ahead and ask
Okay,
the
Ms.
question now,
Pratt,
Mr.
how many extensions were there in this contract?
Objection, Your Honor, that's not relevant here. There was a final extension until the 30th.
Well, the first extension.
Wait a minute. The question is whether the breach of the contract in the earlier parts caused the need for an extension beyond September 30, and whether or not that was appropriate or not. So you can ask questions to that effect.
Okay,
Objections overruled.
okay. Ms. Pratt, did you get a note on September the 30th, which was the final extension? Did the defendants warn you 2 weeks ahead of time that being how that's fifth extension, there would be no more after that?
What I was told by your agent was that you would not sign, and this was long before 2 weeks before that you were not going to sign anything.
Now, in the month of August and September, weren't the defendants fully compliant on all rules, never held anything up at all in any way that you can prove on paper?
Okay, I'm not sure I understand your question.
Did the defendants hold the process up all the month of August and all the month of September? In other words, did we refuse a inspector or any test at all?
Other than the appraisal, other than refusing to let the VA appraiser on the property, no, you let the inspections go forward. You did not, however, let the defendant did not let the appraisal happen.
When was the house appraised?
I want to say it finally appraised in August. I don't have the exact date.
August, is it not August the 9th?
I believe that's correct.
Okay. When was the closing in August set for?
Your Honor, again, this is not relevant to the issue, which is whether the delay in refusing was a violation of paragraph 17. So,
Well, the question is whether or not the breach, which I've already ruled occurred, caused the delay, the need for an extension beyond September 30. So I'm going to overrule your objection. You may answer.
Okay, and repeat the question, please.
Actually, I forgot it. If you'll give me a second, let's go back.
I was listening to him, I forgot it too, so.
At what date was the appraisal?
I believe it was performed on August 9th.
Okay. When was the closing date set?
I want to say it would have been 3 weeks after that.
Actually, could have been August the 30th?
That's correct. That sounds right.
Okay. And who requested that this be put off to be extended? Who asked for an extension?
The lender.
Right. And what was the reason for that extension?
Because after the appraisal is complete, then the loan has to go through the underwriting process, which generally takes about 2 weeks.
So we go to the next extension, which is September the 5th. Is that right or not?
Correct.
Did the plaintiffs cancel out on that or not?
I don't remember what that extension was for, to be quite honest. I
Was
don't have
it-
access to the
Was it
documents any longer.
due to the water test not coming back because of a one-day holiday? Could that be the reason?
That is, yes. Thank you for reminding me.
So.
And
let's
that was
go-
required by the VA.
Yep. And could you say what the next closing date would be?
I want to say it would have been somewhere around the 15th of September.
That's right, September 15th. And there again, the plaintiffs asked for did the plaintiffs ask for an extension or not on that 15th?
I believe we did have to, otherwise we wouldn't have gone to September 30th.
Okay. So what was the reason this time for the September 15th extension?
Honestly, without having the document in front of me, I could not, it's been a year. I've slept since
Does
then.
Exhibit 1 have the addendums to it? Does your
Please.
Exhibit 1 have the addendum, or 4 have the addendums to it?
Have the damages?
The addendums.
Oh, the addendum. No, I can add the addendum, Your Honor. That was
Well, I mean,
it was an exhibit in
just
the original
asked.
complaint.
Okay.
I have
Go
I
ahead.
can have a copy here. I can.
again, remember, counsel, what was a part of the summary judgment motion and the pleadings is not a trial exhibit. So we're getting questions about a document without the benefit of the documents being before the court. But you go ahead, and that's not your fault, Mr. Bailey, so go ahead and continue.
Okay,
Your
we
Honor,
did.
Well, wait a minute.
We did put exhibits.
It hasn't been identified yet. This is the plaintiff's case.
Okay.
Oh, I
Okay.
see. I'm sorry.
All right, when you guys testify,
I
you
see.
can.
I'm sorry.
All right, if they don't, but we won't have them both. But my concern is, I have a lot of documents and I know a lot about this case, but I can't decide it on what I already know. I have to decide it on what's here today. And again, the reason is, what I did rule is that the refusal to allow access initially, and up to the point where they agreed to go forward with it, that period of time was a breach. And so did that cause the delay? And if so, then the damages. That's the issue before the court.
If I remember correctly, the September
Oh, wait a minute.
5th,
There's not a question before you at this point because I interrupted.
I'm
All right?
sorry.
So I'm going to ask you to ask a question now, Mr. Bailey, if you're still on cross. Go ahead.
Okay, since we're talking about these extensions, I would like to ask about the first.
You can ask all you want. I'm just saying is, I don't
Okay.
have them in front of me. Until
Okay.
I get them in front of me, it's going to be impossible for me to know what the written contract was.
Your name's
But you
Lisa,
can
is
ask
that
questions
okay
about
to
it.
call you Lisa?
yes,
Lisa, on the first addendum and extension, could you tell me what happened there?
that was because the refusal of the defendant to allow the VA appraiser.
Did the defendant's realtor say anything such as along the lines, he's put this on hold only until he can get some legal advice? Did she say anything?
No, sir.
Okay. Did you protest on paper in any way? Was there any protest from the plaintiffs?
I'm not sure what you're asking.
Do you have anything on paper saying, we want to continue and we want to close on the original closing date of July 27th of 2003?
The extension the addendum extending the contract would have been sufficient.
That's right. So, did the defendant halt, hinder in any way did the realtor call back and say that the defendant has seen his lawyer and he was on board 100% and want to cooperate 100%, and there will be no further delays from the defendant?
She indicated that you had sought legal advice and that you were going to move forward.
Right. Now, would that time be right around August the 3rd, when I was back on board,
August what?
3rd?
Okay.
That sounds about right.
Okay. So from August 3rd, all through September, you pretty much can say all of August and all of September, we were 100% compliant as far as the legal contract goes. We never hindered, stopped, stalled. or got in the way of any tests and inspections. So, if I could ask you this, when was the inspection that found the faulty straps? Was the inspection that found the fault with?
On the foundation,
Yeah,
I want to say that was like August 23rd, I believe.
and you found out, did you find out in September?
I'm sorry, September 23rd. I
That's
do
what I thought.
apologize.
Actually, did you get a paper dated September the 15th from these inspectors saying that there was a problem?
I did.
September 15th. So probably the inspection would have been a little bit earlier than September.
I would agree with that.
Okay, now, had you been warned that September the 30th would be the last extension, being how that was the 5th extension, that September the 30th was the last go-around that the defendants were going to grant?
Honestly, I had heard that from your agent multiple times throughout this process.
Okay, now, isn't it true, since you had September the 5th to September the 30th to deal with whatever issues that would come up, it being getting this $2,600 problem fixed? And by the way, by contract, were the defendants responsible one dime of this $2,600?
The defendants, I mean,
Let me
in
ask.
real estate, there's always negotiations. Repairs are part of the negotiations.
But doesn't it say in the contract, more or less, that the plaintiffs are responsible for the inspection and responsible for all repairs and damages found in that inspection?
That's not what it says.
Objection, Your Honor. What he's arguing about here is if my clients can have an appraiser, I'm sorry, not an appraiser, have their own inspector, hire their own inspector as they're required to do, and that person finds violations. That's not what's at issue here. What issue here is an inspector required by the VA, which is separate and set forth in a different portion of the contract. That's it.
Right. That's true. I noted that inspections were waived except for appraisal purposes. Appraisal purposes require some inspections, which is what caused this issue. So
Right, so
I would agree with that statement, yes. And,
Okay, so he's asking about a different inspection.
right.
And the question.
You need to ask about, and to clear that up, his objection is sustained, Mr. Bailey, because it's not that you breached the requirement of inspections
Right.
for them, for their purposes, but because by definition, the appraisal process lenders require certain inspections, that's part of the appraisal. So that's the paragraph of the contract we're under. And again, I ruled on page 3 of my summary judgment that the delay was from early July when the appraisal was declined until September the 5th. And actually, I believe that addendum that extended September 5th was like on August the 30th from what I read in my note in my decision. But again, that is the issue, is whether or not those delays caused the final delay beyond September 30th and any damages. So,
Your Honor, the
no,
delay was.
Miss
Don't
Hazard?
interrupt.
Okay, I'm dealing with his objection. You'll have your chance to ask questions later, all right, after he's done. All right, now, go ahead and proceed with the question, and that understanding that the inspections that we're talking about here are part of the lender inspections and appraisal requirement that you cooperate with.
Okay. Did we ever refuse or deny any inspector to come on our property and check it out?
The inspector, no.
Okay, so you're saying that somehow we hindered an inspector and delayed his work, which is not true, is it?
Well, again, you can't testify here. You ask questions.
I got sidetracked.
Okay, ask questions.
Okay. Back to the original question, why wasn't this home following normal home buying procedures, such as the the plaintiffs get such and such and such and such and such done, then go back to the bank, get approval, and then set up the closing date. Why would you go to October or August the 30th and only have an appraisal? By September the 5th, you found out, oh, we need a water test too. And by September the 15th, you find out, oh, we need an inspection too. So you've set 3 dates and wasn't really prepared to come in and close on any one of them, were you?
We absolutely were. What caused the final delay was your request to remove the large shed. That meant that it had to be reappraised. The appraiser did not cooperate because he could not remember that far back.
Right.
So that's why we had to get the engineering certification.
Okay. So you're saying that on August the 30th, you had the right to come in and sign off on this property and close the deal, right?
That is not correct because we still had to meet the VA requirements.
And a water test and an inspection. So that kind of shows that you're setting up a closing date without being prepared.
That's not correct.
Why not?
Again, because of the other delays that were not caused by the VA loan, but ended up being the VA loan being affected by the other delays, that's why it was not ready to close.
Right. And isn't it true that the first delay caused by the defendants only lasted a week and a half? And by August the 3rd, isn't it true that we were on board 100% without any delay, without any interference? And it is true that the plaintiffs had a full 2 months to get their act together. And isn't it true that you requested an extension going into October? And isn't it true that, is that true or not?
I mean, everything you said was true, however,
Excuse me. Let me ask you this. Did you define and ask for a 2-day extension?
I did, yes.
No. The plaintiff asked for an extension. There was no 2-day time frame there. You just asked, from what our realtor has told us, you asked on September the 30th for an extension. We said no. That's the last we heard about any extension. We never got any
You're
papers.
testifying, Mr.
Okay,
Bailey.
sorry.
You'll have the opportunity to
Yep.
testify when it gets to your case. Ask questions.
Okay. So you prepared this contract. Would you say it's legal and binding?
Yes.
Your Honor, he's just asking arbitrary questions here.
Well,
Well,
but they're going back
You've
on.
gone-
wait a minute.
Okay.
Don't interrupt when he's talking,
Okay,
all right?
sorry.
And particularly, don't interrupt me. Now, give your objection.
Your Honor, you've already found that this was a valid contract, so I don't think that's an issue here.
Correct. That is correct. It's a valid contract, so the question is irrelevant. You may not. So ask another question. Objection is sustained.
Okay, now, right now, I don't have any questions. Kim may have, so.
Okay. All right, Ms. Hazard, do you have questions you'd like to ask the witness?
The only question I have is, they couldn't close on the 30th because they needed more funds. I mean, wasn't it needed an extension to get the loan revised? That's why the last extension was needed, to get a revised loan. It wasn't due to somebody failing to inspect the place, it was already inspected. inspection. Now
We
they
have to
need
get the
it-
results of the inspection, though. It can't just be inspected and go, okay, it's done.
The results were given on September the 15th, right?
That it failed, correct?
Right. And so the plaintiffs, were they not trying to get a revised loan?
That is
So that
correct.
they could close on the 30th or not?
That is correct. After the defendants refused to pay part or all of the repair to the foundation, my clients decided that they were going to pay for it, and that's what warranted the change of loan type.
Right. And doesn't the contract state that they have the 7 extra days?
That is correct. However, with all the other delays and the back and forth with the defendants on whether they were going to show up at the closing table or not, I opted to make sure that everything was set in writing. Like, I wanted to make sure that we had the closing date extended regardless of the additional 7 days.
But if you said you needed overnight mail comes on Saturday, doesn't it?
I don't know what you're asking me, I'm sorry.
Does overnight mail come Saturday?
Not all the time, no.
Overnight mail.
Not all the time, no.
All right, well, you did state that you knew that they had till October the 7th, so why didn't we just close? That's what I don't understand.
May I answer with a question?
No.
Okay.
Okay. I'm not sure what your question is. Ask
I
your
asked
question
her-
again.
I asked her if the contract was correct about the extra 7 days.
Okay, point that out to her.
Extension?
Go ahead and ask her that then.
I did, she already said yes.
Repeat your question.
In the contract, doesn't it state there's a 7-day extension granted?
Built
To
in, yes.
either party, really.
Which section of the contract are you referring to?
I believe it's page 8, 420 and 421.
Paragraph what?
420, 421. It's in Exhibit B that we did. That's pretty much all I need that answers my questions.
I'm sorry, go ahead.
That's pretty much all that I have.
That's all you have? All right.
I mean,
I didn't hear an answer.
She said yes.
Okay, you said yes?
There is a 7-day
Right.
built-in extension.
7 calendar days? Yeah, I'm looking at it. All
The
right.
paragraph she's referring to says date of closing shall be July 26, 2023, or as mutually agreed by parties. Notwithstanding anything to the contrary, in the event that buyer and seller are proceeding in good faith, performance under this contract and closing cannot occur due to occurrence or circumstance out of the direct control of either party. The date of closing shall be extended for a period of up to 7 calendar days. Unless otherwise agreed, such extension shall extend the terms of possession and occupancy by an equal number of days as closing was extended.
All right, now you have any more questions?
No, it's pretty much.
All right, thank you. Now, do you have any redirect?
Yeah, a couple of things, Your Honor. First of all, this issue came up, I'd like you to look, I guess we can mark these as exhibits. I think I was up to exhibit 5, so this would be
6 now.
Your next exhibit, whatever it may be, would be 5.
Okay, and this is exhibit 5.
Have you got a sticker on it yet?
No,
Well, let's get one on it, and on 4 too.
I'm sorry, Your Honor, I didn't anticipate that this stuff would be an issue.
You didn't think a contract was an exhibit? I mean, you know, we're still dealing with whether or not the breach is what caused any damages.
Right, but
Yeah.
this will deal with the
Okay,
Your
so,
Honor.
wait a minute. Exhibit 4 is the contract. What is Exhibit 5?
Addendum number 8,
Addendum 8?
yes.
Okay. All right, Ms. Hazard, do you have an
He gave
objection?
us this and said it was exhibit
Okay.
4 when we walked in the door, so you got, it's. getting
Whatever, I don't know what
confused.
you have there, but it's not this exhibit here.
This one.
Exhibit 4 is addendum number 8 to the contract, he says. And Exhibit 4 is the sales contract. All right, show her and then both of them what the Exhibit 5 is, because she says it's different from what she has there, which looks like copies of text.
We
From what
never
I can
got
see.
no exhibit 5. We got an exhibit 4 when we walked in the door.
Okay, well, that's,
And
again,
no sticker,
Well,
I
what-
wrote it on there.
Ms. Hazard,
I'm just saying.
Exhibit 4 is whatever is marked here, not what you have there. What
Okay.
you have there
What is
is
exhibit-
clearly not Exhibit 4, that's the contract.
Okay.
Now, I know you know that,
Oh, the
what that's about.
contract. I'm sorry.
Quit interrupting me, both of you, I'm tired of it.
Sorry.
Quit interrupting. Now, I'm having him show you what the exhibit number 5 is so that you will know. And that's the way it's handled in court. Now, that's why I had them, I wanted everything pre-marked ahead of time so that we don't get bogged down in this, Mr. Ford. So if you got any other exhibits that aren't marked while we're doing this, get them marked so we can keep moving. So, now, once you've seen what it is,
Yeah.
I'm
all
sorry.
right,
Both of them? Can I read it for a minute?
okay, what are the 2 exhibits you have marked there, Mr. Ford?
Please,
You got 2 papers there, what are they?
5 and 6.
5 and what?
6.
Okay, what is 6?
This says 8
Okay.
and 9. Okay.
These were exhibits,
Okay, have her identify them then if she can.
They were
Both are addendums.
exhibited and verified in the complaint. Ms. Pratt, would you tell me what Exhibit 5 is?
Exhibit 5 is addendum number 8 to the agreement dated June 26th of 2023 between Daryl Bailey and Kim Hazard
Okay,
and Daryl Rogers and Michelle Rogers.
Okay, and what is the reason for that extension?
Due to the removal of the 10 by 12 metal storage building being removed, causing the requirement of the VA appraiser to need to comment on the value or lack thereof, the closing date now needs to be extended to on or before September 13th, 2023.
Okay, so what that is an extension for is because there were material objects as part of the house that the sellers wanted to remove, and that would affect the value of the appraisal from the VA appraiser who had come to the house and made an assessment, correct?
It required a comment from the VA as to whether
Okay,
it would.
he needed to come back and make another assessment.
Either that or comment on it, correct?
Okay, was he allowed to do that?
Yes.
When was he allowed to do that?
Oh, you mean, was he allowed by the VA or
I'm sorry.
by the VA appraiser never made a
Yes.
comment on it, no.
I'm sorry,
Okay.
he what?
The VA appraiser never commented on it.
Okay. Now, what is Exhibit 6?
It's addendum number 9. Closing shall happen on or before September 30th, 2023, while we wait on the VA appraiser to comment on the value of the shed that is being removed by seller.
Okay. And what's the date of the extension of the closing date? on
That one was signed by my clients on September 11th, by Mr. Bailey and Ms. Hazard on September 14th.
Okay. And what is the closing date is when?
At that point, on or before September 30th.
Okay.
You're referring to Exhibit 9, right?
Correct.
All right.
Addendum 9.
I'm sorry, Addendum 9, Exhibit 6.
Yes.
Right, thank you.
Okay.
And
Now-
while I'm thinking about, excuse me for interrupting.
Sure.
Addendum 8, when was that signed? Which is Exhibit 5?
My client signed it on September 2nd.
Second?
Yes, and
Is it at September 7th?
Mr. Bailey and Ms. Hazard signed it on the 8th.
All right. September 7 and September 8?
No, September 2nd.
September 2, okay, all right.
Yes.
I was having trouble distinguishing between second and seventh.
I'm sorry.
Well, that's my hearing problem, that's why I was asking, go ahead.
Mine too.
I'm with you, Your Honor, I have the hearing
Yeah,
problem.
me too.
But Mr. Bailey signed it on September 8th, and Ms. Hazard has August 8th, but I'm sure that was just a typo.
Okay, now, ma'am, the closing date was September 30th?
On or before September 30th.
Okay, now you said you filed a motion for an extension of the closing?
I did.
And why did you file the extension of the closing again?
Which extension?
Please?
Which extension?
The one beyond the 30th. It would have been one that was not approved.
Because when we could not get the VA appraiser to comment on the value of the shed that was being removed, we had to contract with an engineering company to come out and do another inspection of the property to make sure it qualified for the VA loan.
Okay, and when they completed that inspection, was the loan approved?
I'm sorry?
When they completed that inspection, was the renovation loan approved?
That was, once they completed the inspection and the defendants said we're not paying for the repairs, and my client said yes, we can, that's when the requirement of the VA renovation loan came.
Okay, so that's when they had to apply for the renovation loan?
Correct.
Okay, and what was the renovation loan ever approved? Did you ever receive notice it was approved?
Yes.
When? September 28th?
I want to say it was.
You testified previously September
was it
28th.
September 28th, I believe.
Okay, and then it was required, the VA at that point asked for some additional documentation.
Correct. They wanted the certification from the engineering company.
Okay, and that was the reason why you wanted to extend the closing one business day.
That's correct. I'm sorry, let me correct that. It wasn't that they needed the certification. They needed the contract signed by Mr. and Mrs. Rogers.
Okay. Now, there's some testimony that you had an additional 7 days?
That is correct.
Was there an extension of the closing by 7 days?
No, the 7 days that you're referring to is automatically put into every real estate contract to allow for things like this. I chose to have everything documented because it had been a very challenging transaction.
Okay. Did they refuse to close on the 2nd?
They refused to extend it, correct. We don't know if they would have showed up at the closing table or not if we had scheduled it on the 2nd.
Okay. Have you had any dealings regarding that issue?
I'm sorry?
Have you had any dealings regarding that issue with the realtor for the defendants?
I'm not sure what you're asking.
What discussions was there about possibly closing on October 2nd?
She pretty much made it clear that we were not going to close.
Who was the one?
I'm sorry, Judy Newman, the defendant's realtor, had made it clear that they were not going to close.
So acting on behalf of the agent, she informed you that they were not going to close no matter what?
I don't think the no matter what ever came up, but she said it I think her words were, I doubt it, it doesn't look good.
Okay. I have no further questions, Your Honor.
I have a question. I'm trying to get get this thing in perspective, but once it came back that the home wasn't properly anchored according to VA standards, then there was a request that that there be a sharing of the expenses. I think the first request that the seller pay, and then later that buyers would share. And
That's
then,
correct,
all right.
yes.
And my question is that was specifically in the contract, is that they were not obligated to do that, correct?
It's not specifically in the
Right.
contract.
So
but
you
it
just
is
asked for it
negotiated.
as a hope that they might.
That's correct, it's part of
But you understood at the
negotiations.
time they were not contractually bound to do that.
That is correct.
All right. All right. Now, as a result of that question or a couple of questions I asked, do you have any further questions?
Your Honor, I don't have any further questions.
Do either of you have any further questions about what I just asked and nothing else?
No.
Okay, all right. I believe you're done then, for now, anyway. Step down.
Okay.
You can step down.
That way nobody gets taken out.
Would you anticipate needing her back?
No, I don't.
Okay, I guess you'll be excused. You need to leave the exhibit with him, yeah. Yeah. Okay. Now, just for the record, I have up here the pre-marked exhibits.
Excuse me, Your Honor.
Wait a minute. Okay. Yes, you may leave. Yeah. Actually, I'm looking at what's pre-marked here. This looks to me like it says Trial Exhibit 5. I don't know. Mr. Ford, can you interpret that for me? What is that exhibit there? It says Indiana lease.
I have one.
That's one? Is that a number one?
Yeah, one,
Okay.
and then you'll
All
see
right.
underneath. I
Well,
have
it's just
two.
confusing me, the writing, so.
Oh, I'm sorry.
All right, that's okay. I'm going to go ahead and put a 1 in my writing so I know what it is. Okay. And then the others, I think, I thought that's what it was, but I just wanted to make sure that they're not, I didn't have them out of order.
Your Honor, those are 1, 2, and
Wait a minute, let me finish. Okay, then we've got 2, which are payment receipts of somebody, I haven't looked at them yet, and, because they haven't been touched by 2. And 3, which is another group of receipts, okay. And then 4 is, wait a minute, 4 is a contract, 5 is addendum 8, and 6 is addendum 9.
Yes.
And that's where we're at right now on yours, okay.
That's
Okay,
correct, Your Honor.
all right. So you guys have that, so you know what the exhibits are.
She's marking them right now.
Okay, all right. Now, your next witness,
Your Honor, I would call Michelle Rogers, please.
all right? Would you raise your right hand to be sworn, please? Do you solemnly swear that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God? All right, have a seat right there. And then slide that microphone over to your left as far as it'll go. All right, thank you. All right, you may inquire.
Thank you, Your Honor. Ms. Rogers, would you state your name for the record?
Michelle Rogers.
Okay, and you're the plaintiff in this matter?
Yes, I am.
Explain what your position is with the plaintiff.
I was attempting to purchase a property from Mr. Bailey and Ms. Hazard.
Okay, and you saw what we had and marked as Exhibit 4 when Ms. Pratt
did.
was up here. Was that a copy of the contract?
It is.
And you had signed that contract?
I did.
Okay, and then there were extensions of the closing date, correct?
There were.
Okay, and those were Exhibits 5 and 6 that were shown to Ms. Pratt before?
Correct?
And you also signed those documents?
I did.
Okay, and what was the final closing date?
It was September 30th.
Okay, and did the building close, or did the property close on the 30th?
It did not.
Why didn't it close?
Because we needed an extra day or two for clerical issue. The engineering company that we needed to get the certification from was not open on Saturdays. And we were notified from the VA that, yes, you're approved, but to close, we need to have that certification in our hands. They wanted to make sure, of course, that what was needing to be fixed was going to be fixed. And since the engineering company wasn't open on Saturday, the earliest that we would be able to get the documents that were required were Monday, the following Monday, which I believe was October 2nd.
Okay, how did you receive that information?
From our financial, our mortgage financial man, Jeff Cost.
Okay, and he was in, he wasn't-
He's in Florida,
Okay,
but we have dealt with him for several years with several properties. So he's a person that we know and trust.
okay, now when you received that information from Mr. Cost, what did you do to try and remedy this?
We contacted the realtor for Mr. Bailey and Ms. Hazard and asked for the extra day or two for clerical to get that document needed,
Okay, and what happened?
and they declined.
Please?
They declined.
Okay, so were you told at any point that you would be able to go forward with the closing?
We were not able to go forward with the closing without their approval.
Okay. And there was no extension filed? I think that Ms. Pratt testified that she drafted another extension and they refused?
Correct.
Okay. So what happened after that?
After that, we had to scramble to try to find a place to go because we had planned on closing the 30th and our move-out date was October 1st. The home that we were in currently was sold and we had to be out, and we were already pushing the limit on being able to move. So we had planned that we were moving to the Washburn address, and all of a sudden we weren't. So we had to try to find a place to go. We have 4 big dogs, so you can't, rent anywhere. A lot of people say no to you. So it really put us in a very bad situation. Fortunately, we heard of a property from someone we knew, and she was willing to extend us the lease that you've read until we figure out what we're going to do. So the property came available, and we were able to purchase May 31st of this year.
So you're able to move into that property?
We moved into that property, yes.
And how long did you live in that property?
We moved in October 3rd. All the utilities were turned on, and we had been there since.
Okay. And so what did you end up doing with that house?
We were able to purchase it May 31st of this year.
Okay, so you paid rent until the end of May?
Yes, we did.
And you paid utilities until the end of May?
Correct.
Okay. And those are the costs that are...
Those are the costs, including storage, because we had to put everything into storage
Okay.
until we knew where we were going to go. So we accrued quite a few charges for storage that we would not have normally had we moved into Washburn.
Okay. Your Honor, may I approach the witness?
You may.
I have exhibits. We previously marked down to
Okay.
Ms. Rogers, would you, the first document that's marked Exhibit 1, can you explain what that is?
What was your question?
Can you explain what that document is? Identify that document.
This is our lease agreement that we had with Vicki Jones.
You're referring to Exhibit 1? All
Correct.
right. Go ahead.
Okay, that's the rental agreement.
That is the rental agreement.
And how much did you pay per month?
I paid $600 a month.
Okay, and you said that, when was the first month that you paid rent?
October 1st,
And when was the last month that you paid rent?
June 1st,
Okay, so how many months did you end up paying rent?
9.
9? And what, at $600 a month?
Correct.
So that would be a payment of $5,400?
Correct.
Okay. And that's how much rent that you paid in the period between the time that you were unable to close on the Hillsborough on the 501,
VV, Indiana.
yeah, and then this new property.
Yes.
Okay.
Yes.
Okay. I'd like you to look at Exhibit 2. Can
Okay.
you tell me can you identify that document for the court?
Yes, this was a storage unit that we had rented temporarily because we were planning to move to Hillsborough and thought that we just needed it for a couple of months. So we took this out. As you see, the original date is September 13th, and it's paid through October 12th. We thought it would be a month or two and that we'd be able to have it delivered to Hillsborough. It's one of those units, kind of like a pod, and you put everything in it and then they move it for you. But because the real estate contract did not go through, we ended up having to leave our things there for the last 9 months. And,
Do you know how much was the rent there each month?
yes, it was $261 a month.
Okay, so how much did you end up paying for that entire period when you had to use that storage?
Unfortunately, I don't know. I can't do math in my head.
Previously identified as $2,762.40?
Probably for 9 months.
Yes.
Because of course, I wouldn't say September was their responsibility, that was our responsibility. But because we could not move into the home, I feel that it became theirs.
So that would have been from October to 1st of June?
Right.
Okay. I think that also during that period, I'd like you to look at Exhibit 3. Can you tell me what that is?
This is a copy of the electric bill in that property, in the rental property. We had to pay from October 1st. I believe it was turned on the 3rd, October 3rd, until June 1st. We closed.
Do you know how much you had to pay for electricity in that period?
It was an average of maybe $250 a month.
I have a total here that you've provided of $2,701. Does that
Okay.
seem fair?
I would agree with that.
Okay. Now, you had to pay water as well?
Yes. And
Do you know how much your water bill was for that period?
it runs $90 every 3 months.
Okay, so how much did you pay total?
For water, that would be, is it 240? I'm not good. 270? 270
270?
for 9 months.
Okay, are there any other expenses that you?
No, sir.
No other expenses? Did you ever have to pay moving costs, or did you ever?
Oh,
have to
yes,
pay-
of course. I thought we were talking about utilities. I apologize.
No, anything other than what?
Okay, yes, we had $1,000 in the truck for fuel, and I believe another $500 in labor to move us out there, which of course we wouldn't have had that if we were moving straight from where we lived in Cincinnati to here.
Okay, so
But that
how much was that cost?
I believe the total was around $1,500, maybe?
You've represented $1,800?
Okay, that
That's
sounds,
$600?
I would agree with that, yes.
Okay. Did you ever have to rent any trucks to move your equipment
Yes, that cost is included in that.
in the $1,800?
Yes, sir.
Okay. Okay. Now, how much did it cost? Did you have any further expenses in looking for a new property?
Oh my gosh, yes. I mean, we had to drive from Vevey, Indiana up to Ohio every time Lisa would find a property that fit within our availability. So that's an hour and a half one way. I believe it's 78 miles one way. So there were several Saturdays or Sundays that we would meet with her to look at other properties. So we had to start over. So we're trying to stay in the Ohio area because of hobbies and family, but we were not able to find another property in Ohio.
Okay. And did you look other places as well?
We did.
Where else did you look for property?
We looked in northern Kentucky, southeast Indiana. We looked in northern Ohio, as far north as Sydney. Honestly, Your Honor, we would do a search for state. I mean, we were willing to travel anywhere for the right property. Our kids are grown and we'd like to stay around here, but it wasn't necessary. What was necessary was to find a place that worked for us. So,
When you say work for us, you mean one that you could have-
affordability and had to be big enough for, the dogs and us. So
How long did it take you to find the proper property to move into?
we would probably still be looking had the property that we were renting not come for sale. It was in probate, and the probate finally ended in, was it the 1st of September? Something like that, no, wait a minute. It was May, March, April. So we had like 30 days from notification that the probate was over, and the question is, would you like to buy? And we said, if it's affordable, what do you want? And it was affordable, so we did, within 30 days, do a new option to buy through Jeff Cost still, and we bought it from private owner, so there wasn't anything, no competition or anything like that. So we closed May 31st.
How much money do you estimate that you paid in looking for the other house and driving to the other areas? Within the period, and I'll say the period began October 1st of 2023 until you found this house, and you said that was at the beginning of May.
Until we were able to purchase it. I'd say every bit of $500 in fuel.
Please?
Every bit of $500 in fuel.
Well, what was the total amount of cost and time and fuel and that you would have spent? An estimate of the amount of money it cost you to do that?
I would feel maybe $750 for,
Total or each month?
no, total.
$750.
Because there wasn't always a property, but every time there was a property, we would travel to look at it. It's been slim pickings out there for finding something. The market's not friendly. So, there weren't a lot to look at that fit in our budget and setup.
Okay, let me go over here, let me review this. Now, and tell me if I'm wrong, but this would be the review and we'll get the total. You're testifying that your rental expenses in that period for the 9 months were $5,400.
Correct.
Okay, the storage unit expenses were $2,762.40.
Correct.
The electricity bill was $2,701.
Correct.
The water bill that you paid for that period was $270.
Okay.
The amount of moving expenses and the labor that you had to help you move was $1,800.
Correct.
And the U-Haul rental that you had to buy and the gasoline for that was $590.
Correct.
And then the amount of time you spent driving around looking for the additional money was $750.
Yes, sir.
Okay. Just a second, Your Honor, and I'll give you a total.
All right. We're going to take a 10-minute break here. When we come back, then you can do your cross, and you will.
Yes, that'd be fine. That would be fine, Your Honor. Yep.
All right, 10 minutes.
Thanks for the break.
All right, so back on the record.
Your Honor, we had gone through and we verified all the categories, and I would like to repeat them again and have her verify the total amount.
I thought you were done, but you want to, go ahead.
Okay. The figures that we went over before, and right before we took a break, for me to total everything up, we went through each category individually that you had testified to. And the total came to $14,273.40.
Correct.
Is that correct?
Correct.
Okay. Your Honor, there is one other issue I'd just like to add here that came up in the discussion. Ma'am, during the time that you were, during the course of this contract and we were trying to work everything out, were there any times when the defendants refused to comply with either the VA appraisers or the requirements that the VA was requesting inspections?
Yes.
There were. Okay. No further questions, Your Honor.
Mr. Bailey, you may cross.
Okay. Can I call you Michelle?
Yes.
Okay. At what time did we refuse this VA inspection?
The appraisal,
The appraisal, excuse me.
correct.
Yep.
When we asked for the appraiser to come, you had decided you weren't going to sell, and you said no one is coming on this property.
Did I not say this sale was on pause? Did not my realtor say this sale is on pause until Daryl can seek legal advice? And wasn't that about a week and a half duration? And on August the 3rd, did not our realtor say everything was on track and would go on without delay?
It may have been a week and a half to 2 weeks, but it was a delay caused by you and that caused a chain reaction of events.
So you had it appraised on August the 9th, and the plaintiffs made a sales date closing of August the 30th. Is that right?
August the 30th, that sounds right.
Your Honor, that's an earlier closing date. It's not really an issue.
Well,
No, wait a
he's
minute.
talking
I'm
about-
going to overrule your objection. You may answer the question.
Okay.
I believe somewhere around there, yes. Without looking at the contract,
why wasn't that sale carried through by the plaintiffs? In other words, couldn't you have come in and signed off on the house and bought it on August the 30th, had you wanted to and had you chose to do that?
would the delay caused a problem with the closing because we didn't have the report back in time? And then you had asked for the shed to be put into the sales, you asked us if you could have the shed, and we agreed. Well, then the appraised report changed because the VA said, we don't know if the property is the same value now because you're removing a building, and we needed more time for the appraiser to make a comment about the value of the building, whether it changed it or not. And the gentleman would not get back with us.
But I'm asking this question. You negotiated with us over the shed, but you didn't have to. You requested, is this not right? You requested an extension, and we negotiated for that shed. But actually, you had the option of no negotiation and go in there and buy this place on August the 3rd.
Your Honor, he's just contradicting her statement. She just...
Well, I mean, he's cross-examining her, so I'll overrule.
We were just trying to, we were trying to be nice. You wanted the shed. We didn't care if you took it. We didn't know it was going to cause a delay. We didn't realize that the shed could or would change value of a property. We were told that by the bank.
Okay, so will you agree with this? You wanted an extension, and we wanted the shed, so we kind of made a deal. Is that not right? Well, let me finish. Since the defendants did pause once for legal advice, it was only fair to give the plaintiffs one pause. So, is it not true that you guys asked the plaintiffs, asked for an extension, and I said, if you'll give us the shed, yes. Is that the way the deal went? Yes or no?
Your Honor, I'm going to object. It's clear from the documents that have been put in.
I'm going to overrule your objection.
Okay.
You may answer.
Okay, we
Yes or no?
ask it again, please.
The question was, when they asked for the shed, did that resolve? When you asked for the extension, they asked for the shed.
Okay.
Is that true or not true?
I don't believe it had it. No, that's false. The extension was not given because of the shed. We were asking for maybe the washer and dryer or something like that. There was something to do with the washer and dryer. They didn't want to keep it, and they said, well, can we have the shed? And I'm like, I don't care. Sure, you can have the shed. And then when we notified our finance that the shed was there, then they said, well, that might change. That's a building. It may change the value. We have to have the appraiser come out or make a comment on his report that it changed the value or it did not change the value. That gentleman never would respond, and that's when the VA said we need to have an engineer come out and do his job. And that's when we needed the extension. It wasn't because of the shed directly, it was because of the lack of the first appraiser not responding and giving comment on the value.
But he appraised, is it not true that he appraised the house?
He appraised the house.
So what you're saying is the trouble that you had stems from this appraiser and him not cooperating with the plaintiffs. Is that what you're saying?
No.
What are,
The trouble began with you not complying with the contract obligation. That's when it all started. When we met and you accepted our offer and everything was great, you both worked at GM, you both Daryl, ha ha ha, we're having fun. You guys are nice, we're nice. And then the brakes got put on for reasons you know and she knows that I'm not going to go into.
yeah.
And then you tell your realtor, I'm not doing it, I'm not selling. And that caused 2 or 3 weeks. And I have that in text messages.
For the record, Your Honor, we don't,
No, you can't testify, just ask questions.
do we work at GM, General Motors?
Did we what?
Do we work at General Motors?
You worked at General Motors and he worked. Used to. You sat on the back porch and discovered that you both worked at the
That's
same
true.
place.
But now, the time frame, is it not true, the time frame that you're talking about was in the first 2 weeks of this contract?
Correct.
We've already been over this once, that I saw, did I not seek legal advice? And that time frame only lasted for about, I'm gonna say, 2 or 3 weeks, and did not my realtor say on August the 3rd
Your
that
Honor,
we
I'm
were
just-
on board,
Wait till he's done asking his question.
that
Don't
we were
interrupt him.
on board 100%? And did not we comply all of August and all of September, except for the September the 30th, when we refused a 6th, count 'em, 6 extensions? Is that not true?
Your Honor, this is not relevant because the only
Okay, I would
issue is...
sustain your objection, not because it's not relevant, but because that is the most convoluted and complex. You ask about 6 questions in one.
I'm
You
sorry.
need to break your questions down and ask them one thing at a time. don't put all these conditions in there.
Okay.
You can ask about all those things, just don't do it all in one question,
I
because
see.
quite honestly, I think you're confusing her, I know you're confusing me. All right?
I'm sorry.
Objection sustained for that reason.
Okay.
All right, not for relevance. Now, go ahead and ask questions according to my instruction.
Did I get an extension at the first of the contract for about two weeks?
It could be two,
Your Honor, again, I'm going to have a standard objection here because the issue is what are the damages and at the end, not what the,
Well,
any
yeah, but it's
extensions.
also whether their breach caused the delay beyond September 30. So I'm going to overrule your objection.
Well, he's asking about an extension earlier.
I know.
Okay.
The whole thing about the breach.
Right.
So again, it's overruled. Now, you can go ahead and answer the question.
okay. I don't know if it was 2 weeks or 3 weeks while we waited and for you to decide what you were going to do. Because it wasn't just a matter of meeting with an attorney. You had already stated through your attorney, through your realtor, that you were no longer going to sign to complete this sale. That was information given to us early in the process, and it was a on again, off again, on again, off again decision-making on your behalf. You were going to comply, you weren't going to comply. You were going to sell, you weren't going to sell. You put us through hell for months, not knowing what we were going to do. And all the while, we're in a house that's sold and we have to vacate. So we gave all the extensions that we could give. We gave all the deals that we could provide, and always met with, well, I don't know, maybe I feel like selling it to you today, maybe not.
Okay. Who asked for the last 4 extensions? All through August to September. Did the plaintiffs ask for the extensions?
I believe we
Yes or
asked.
no?
I believe we asked for extensions.
Okay. Did the plaintiffs show up and buy the house like the defendants were ready to sell on that particular day? Yes or no?
We never went to closing. How do I know if you were going to show up or not?
Because you canceled and asked.
I
Did you
didn't
not
cancel
all
anything.
the closings? And did you not ask for another one later on? On 4 of these closings, all of August and all of September. Let's get this clear that
Your Honor, I'm going to object. He's asking a question that's not relevant.
Okay, well, again, I'm going to rule your relevance. I'm going to sustain on the basis that it's a multi-compound question
Sorry.
again. So, ask a question, a point at a time.
Okay.
Not including several things.
Okay.
And try to avoid testifying.
Okay.
Because you're going to get your chance to testify later.
Okay.
But, you don't testify when you're asking questions, all right?
Okay.
Now, objections overruled. On that basis, you may proceed.
Okay.
Your Honor, I'd like to object to this line of questioning. Here's the section that he's claiming is why didn't you close or go forward with the closing sometime after the last extension on September 30th. And if you look at the contract, it says that section only applies if the parties are both acting in good faith. And you have already found as a matter of law that he did not act in good faith and breached the contract, given his failure to comply
Breach
with.
of contract is, all breaches of contract are presumed to be intentional. But what I ruled is that they breached the contract when they said they weren't going to sell, when they refused to allow the inspection or the appraisal initially. That was a breach. And then the question is, how does that breach affect the September 30 closing date? And if so, what are the damages?
Right, but
So I think, based on that, I think it's relevant, all right? And again, remember, my ruling on summary judgment was based on the materials that were submitted there. And if those materials aren't submitted in this proceeding, then I can't consider them. So your objection is overruled. Now, that said, ask another question. Because I don't remember the last one. I doubt if she does either.
So, on September the 5th, which is the 3rd closing, did the plaintiffs request that?
Did we
Request an
request?
extension to September the 5th.
Yes.
And did the plaintiffs show up to buy the house on this third or fourth extension?
We didn't show,
Well,
nobody
wait a
showed
minute.
up because there's no
You-
closing.
Wait, your attorney, I think, wants to object.
Yeah, Your Honor, I'm just going to continue objecting. This has already been an issue that you've decided
Okay.
that
All right,
his-
I'm going to sustain that objection because, again, number one, you said on the third or the fourth extension, and you need to ask one at a time.
Okay.
And the question is, inherently, is when you're asking her, did they show up? If there was an extension, then, common sense tells me no. So, and I'm not saying that nobody showed up for for that date because it was extended, wasn't it?
Yes, it was.
Okay, so let's ask questions that mean something then,
Relevant.
okay?
On the day
I
of-
should say us, you.
Okay. On the day of these signings, did the plaintiffs show up on 4 of them to buy our home, the residence? On the day of the closing, on 4 of these, did the plaintiffs show up to purchase the house? Yes or no?
No, there
Wait a
was
minute,
no
you have an
closing.
object- If you're going to object, don't
Yes.
just stand up, object, okay?
Yes, I will. Your Honor, I'm going to object here because the date of the closing was on the 30th, and he told us that.
I'm going to sustain that objection.
Okay.
Nobody has to show up on a date that's set, that's extended, so move on with something that's relevant.
Okay. On September the 30th, it's not true that you were warned that that would be the final date, yes or no?
Objection, Your Honor.
That is overruled.
Can you repeat the question, please?
On September the 30th, when you didn't show up, yes or no?
No.
Were you warned 2 weeks ahead of time that would be the last extension, that the contract would be over, yes or no?
Correct. You said you were not going to extend
I said yes
any
or
more
no.
extensions. You were not going to approve any more extensions.
So,
Prior to the closing date, you said no more prior to the closing date.
okay. Besides the first time, did the defendants work with you 100% all of August, all of September,
No.
cooperated?
No.
Can you say which area we refused to cooperate?
All communications were a struggle. Every time we asked anything or needed information, it took 2, 3, 4 days to get an answer from you, and not just from my realtor, but from your own realtor, where she would say, I haven't heard anything, I don't know anything, they haven't made a decision.
Well, okay, that's your answer. Kim may, Your Honor, Kim may have a...
Don't address your questions to me. You have to address questions to her. Don't try to make a point to me during your questioning. You do that later in the case, okay?
Yeah.
Ask questions of her.
Well, I was
Don't
gonna-
address them to me.
I was going to ask Your Honor if that I'm done questioning her and that Kim may have a few questions.
You don't have to do that. I'm going to ask her that anyway because she's a party.
Okay.
Yeah, she gets the right to question from the law, not from you.
Okay.
So if you're done,
All right.
just tell me and sit down. All right. Now, Ms. Hazard, you can inquire.
I do have a question about the storage. I was wondering why you rented this storage prior to knowing that there was not going to be a closing.
Because at that time, I anticipated that we were going to close. We had September 30th pegged.
That's not the question. Why you rented it before?
Because
You
we were
knew the
preparing to
foundation
move.
expired or failed, and you knew
We were preparing to move. So when I took the storage out, it was for 1 to 2 months so that we could start to downsize, pack things, and get them ready to move. It was basically to get things out of the way until we moved.
Now, why did you not move your things when you moved? You moved into a home that you later purchased, you stated.
Because I didn't want the cost of moving twice. I didn't know if we were going to stay in VV or find a permanent home in Ohio. That was just a temporary home, as far as we knew, October 1st. It was a temporary home in VV, Indiana. We had nowhere else to go but there. So why would I want to move everything there just to move it back? It was cheaper to leave it in Ohio, where if we bought a house in Ohio, we could get it from Ohio.
Well, it wouldn't have been cheaper because you incurred a pretty big bill, so it wouldn't have been cheaper. Doesn't the property you have now have a 2-car garage?
Of course it does.
Yeah, well, that's what I'm saying. Why would you pay $260-something for storage when you moved into a property that
Again,
has a 2-car garage?
we didn't know where we were going to go.
Then don't answer her question until she's done asking.
Okay.
And finish your question, and then don't try to add to it while she's answering. So in other words, don't talk over each other. Now, let's start over. Ask your question, Ms. Hazard.
I apologize, Your Honor.
That's right, you're both doing it.
I just don't understand why you wouldn't have moved your stuff, and it would have been cheaper.
Speak up, ma'am, I'm having trouble hearing you.
I just didn't understand why you wouldn't move your stuff with you. I mean,
We took what we had to with us. So we didn't know where we were going to be or for how long. As I said before, we were still looking for a place in Ohio. So why move everything to Indiana when we're going to go back to Ohio? We didn't know. So
you didn't have to incur a $260 a month bill. You could put it in
I
your
wouldn't have
garage.
had to if you would have sold me the house. I would have just moved into that house and it would have been
I
done.
understand that. I understand.
Okay.
I'm just saying, you said it would be cheaper.
I had to do what I had to do.
If it was cheaper, or wouldn't it have been cheaper to just put it in your shed or your garage?
No, ma'am. There wasn't any place for everything that's in there.
Okay. That's fine. I had another question, but that's okay.
All right, thank you.
Yeah.
Any redirect?
No redirect, Your Honor.
I do have a couple of questions. The place that you rented that's in Exhibit 1, is that the place you purchased?
Yes, sir.
All right. And where was the storage? You say this was like one of those storage pods, like a truck?
Yes,
They have
it's-
something they can
it's
pick
in
up and put
central
on
Cincinnati.
Like it looks like a semi-bed, but it's really a
Right.
self-contained unit they put on a truck.
It's called units or pod.
It's modeled after pods? Okay.
Yes.
And where was it left?
It's in Cincinnati, in central Cincinnati.
Okay.
Right by 75.
Well, I just want to know. the property.
Okay, yeah.
And,
Which is like, it's about 20 minutes from where we were
Okay.
living.
all right. Now, you rented that place, and as I understand it from the testimony and the exhibit, it was $600 a month.
Correct.
And what would your monthly payment have been on the house had you closed?
$1,200.
All right. The other thing is that the closing was extended to September 30. I don't think anyone's talked about this, but the contract provided for basically 30 days, possession 30 days after closing. Because the original date, I believe the contract was June 26, 23, and I believe that the possession was July 25, so it's 30 days. So you would have had so you would have, even if you had closed on the 30th or on the 2nd of October, if that was a proper extension request, you would have not gotten possession for 30 days after they're under the contract, correct?
Correct, but we were still in the house, and we were allowed in the house that we were priorly in
I understand
until
that.
October
But
1st.
I know, I understand. I mean, I've seen this happen where people get caught between having to give up possession of the house they sold and the one they bought. But basically, contractually, you weren't entitled to be in the house until 30 days after the closing, correct? You know that? Because that's what the contract says.
Yeah, I believe that's correct.
All right, thank you.
Objection. If I'm allowed.
Well, your objection's overruled, so it's actually in your favor, because what I'm trying to figure out is when could they have been in the house, so that if I rule that you're liable for damages, when does it start? So I would overrule your objection. All right. Now, based on my questions on that point only, do you have any further questions you would like to ask Mr. Floyd?
Just one thing I'd like to clarify, and maybe sure. You didn't have to leave the house you were living in Coleraine Township until October 31st, correct?
No, it was October 1st.
October 1st.
Yes.
Oh, okay. No further questions, Your Honor.
Mr. Bailey?
Yes. You say that we had 30 days. If you would have bought the property, that we had 30 days to move out. Had the property gone on to sale, we actually negotiated 45 days to have to move out. Do you remember that?
Yes, I do.
Okay, so my point was, Your Honor, instead of this 30 days, well.
I haven't seen any addendum to that effect. So,
We do.
okay. So you have to ask the questions about what I asked. You can't bring up new material on that
Okay.
because that's not in evidence.
Okay,
Right.
so he asked about the 30 days. Do you have an addendum on the contract that says we're allowed 45 days?
There is.
Okay, that's all.
Okay. Ms. Hazard, do you have questions you would like to
No,
ask?
Your Honor.
All right.
No, thank you.
Thank you. And you do have the right to redirect on theirs. Anything else? On that point only, or what they asked?
I'm sorry. You said that there was an additional addendum giving you 45 days?
They originally had asked for 45 days. They said they needed to find some place to move to, and
Okay,
we were
that would have been under the original contract,
correct.
but there were subsequent extensions of the time,
Right.
which overruled the 45 days, correct?
When he finally decided that he was going to sell it, that 45 days got pushed back even further, closer to our deadline of having to be out of where we were, but we still extended it out of good faith.
Okay, no further questions.
All right, you may step down, Ms. Rogers. Next witness. Your next witness, Mr. Ford.
Your Honor, we would close here. We would just move to admit exhibits 1 to 6.
All right. So, he is moving to admit his exhibits, Mr. Bailey, Ms. Hazard, and those are Exhibit 1, which is a residential lease in Indiana, 2, which I believe are electric bills, 3, which are water, or storage bill, 4 is the original contract, 5 is, we've got these marked as state, they need to be plaintiff. 5 and is a addendum 8 and 6 is upside down, put it upside, straight up, which is the addendum 9. So, do either of you object any of those exhibits being admitted?
Yes, Your Honor, I do.
All right, and what is the legal basis?
The legal basis is on the electric.
No, the legal basis, don't argue whether this, I mean, just because they're admitted doesn't mean that they're entitled to it. It's just whether I'm going to consider that. So, you have to have a legal basis for that.
It's not actually a receipt, and it charges us twice for the same bill.
Well, I understand that. You can argue that, but the question is, I got to have the evidence for that to be established. So, okay.
I guess not, Your Honor.
All right, I'm going to overrule that. Again, just because they're admitted doesn't mean they're going to get the damages. It's just evidence.
Okay.
And then you're entitled, in your case, to attack that evidence.
Okay.
All right? Ms. Hazard, do you have any objection, legal objection?
About the addendums?
About any of the exhibits being admitted, yes.
Only that these addendums are associated with other addendums. So, like, there was a deal.
There may be, but, you know, those haven't been proffered yet, so. But the question is, do you object to any of these? And if you want to offer those in your cases, you may. It's up to you guys. Here.
I'd have to go through all the addendums to know which one.
These are 8 and 9, those are two
so-
of the extensions were testified to. All right, I'm going to admit them.
Yeah.
All right, and plaintiff is resting. All
Yeah, we
right.
would rest, Your Honor.
All right, Mr. Bailey, now, it is your case. Do you have any witnesses to call other than yourself?
No,
All right. Do you wish to testify on your own behalf?
I do.
All right. Gather up any materials you need and come up here to the witness stand, and I'm going to swear you in.
Okay.
And if you have any other matters you want to mark as exhibits, the ones you've already marked are here. I'll put those up there next to the stand so you can identify them.
Okay.
All right? So come on up here. What are those exhibits there that are on the pedestal, Mr. Ford? Looks like copies, okay.
Oh,
Yeah.
all right, these are the copies.
Yeah. Pardon me?
These are the copies.
Copies, I think I have them. What are those, 5 and 6?
It's 1, 2, 3, and 1, 2, and 3.
Okay, I already have those. Okay. All right, I thought they were duplicates. All right, wait a minute, stand up. Raise your right hand, please. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
All right. Now, so you'll have these available for your testimony if you decide to testify on them. These are exhibits, plaintiff's exhibits 1 through 6 that have been admitted. And, wait a minute, I think one of these, I need to paper clip this exhibit 4 together, they're loose, which is the contract. And then there's also, here is your exhibits that you previously marked and submitted to the bailiff per the court's instruction. And let's see, trying to figure out where this is. 449 would be these last 2 pages, so that would be this one, all right. So I'm going to paper clip together exhibit 4, the original contract, and then exhibit, there's exhibit 6. All right, I've gotten 5 attached to something else here by mistake, it looks like. See if I can find it. You have any of the yellow exhibits stickers there? Yeah, there you go, okay. I gave that to you. All right, and that would be, oh no, that's yours. All right, wait a minute. 6. Well, I've got it up here somewhere, and it's unmarked. I can't take something that's marked up. 1, 2, 3, 4, and I just had it because I saw it when I went through it. So it's got to be mixed up here with 1 somewhere. You did give it to me, didn't you? Thought you did.
5 and 6.
Yeah. Well, that is really strange. Can we get a duplicate exhibit 5, Mr. Ford? Oh, here it is. Okay, it was mixed up with 1. All right. Yeah, those pages were loose, and when I was moving them around, exhibit 1, it got mixed up with that. So now I have them. So there they are. So anything you need, you can refer to. If you're going to refer to something, make sure you mark it. If you've got any new ones beyond what you've already marked, I don't know what your last letter is, you'll start with that. All right, now, remember, you're going to testify, you're not going to argue. So just testify as to the events and whatever facts that you think need to be established in your testimony. So you may proceed.
Okay, my name's Daryl Bailey. I'm the defendant here in court. I am looking at the electric bill.
And that is
No.
plaintiff's exhibit what?
That is exhibit
2 or 3, I think.
C.
Okay, here, look at the ones here instead of yours. If yours are duplicates, use these, and that way we won't get them confused.
Yeah, that is, I really can't read his writing, Your Honor.
I have trouble too. Let me see.
It's so little, and it's in parentheses.
3, I believe. Yeah, that's 3.
Okay, that's exhibit 3. The plaintiffs have handed in an electric bill, which really is not the bill itself. I'd be more comfortable had they brought in the receipts and the electric bill themselves. So at one point, have to switch papers. At one point, they charged twice. It is, still looking for electric. There we go. On the same bill. I don't have my glasses.
Are they with you?
3, 7, 20 something. That's another thing. This is not a bill receipt. This is just a computer copy. The dates on some of it's missing. It's not been notarized. But anyway, on 3/7/2000 something 2 something that's faded out. You can't read it. It's not there. And on and on 3/7, it's the same bill, basically. They're charging us twice. And the point is here, no matter where they move, they were going to have to pay an electric bill. Asking for the electric to be paid, I think is a little ridiculous, because you're going to, if they had bought the house on Washburn, they'd have paid the electric bill there too. So I ask that this be thrown out.
Anything else you want us to testify to?
Yeah, on the housing contract, they bring in no actual rental receipts. They say they moved in October the 1st. They bring in no
I'm sorry,
rental
what-
receipts.
I couldn't hear what he said and what section is
Said
it?
they moved in on October 1st, is what he said they say.
Yeah.
I'm sorry.
The plaintiffs moved into the dwelling October the 1st, so the contract says.
Yeah.
Okay? They're wanting to charge us rent money, when in fact, if they had bought the house, we wouldn't have had to been out till the middle of November. Number 2, there's no rental receipts from the landlord. 3, they're in the house that they claim they spent all this gas money looking around at. They're living in the house that they moved in October. So the rent has no actual rental receipts. So I would say that they've used this money as rent to put down on this house when it was sold. They have no rental receipts, and they have no proof of when this house was bought. For all the court knows.
Your Honor,
Yeah.
I'm going to object to this line of questioning, and here's why. He has to present evidence. He's just making speculation.
Well,
When he says,
I understand that. I'm going to overrule your objection because what he's saying is they have no receipts. That's factual statement of his claim, and I'm going to hear that. So I hear what you're saying, And again, if he argues, anything he says that's argument, I'm gonna disregard.
Okay.
I mean, I deal with lay people representing themselves quite often, and I continue to say and tell them the same thing.
Yep.
You can't argue, you gotta testify. If you argue, it doesn't mean anything. Argument's at the end of the case.
Okay.
So with that understanding, go ahead and continue to testify.
Facts are they moved in the home that they're living in now and purchased it. The facts are they claim that they rented it right up until it was court date, and then they can present this rental agreement. The rental agreement has them putting no money down, no damages if they don't pay rent on time.
Your Honor, I'm going to.
That doesn't really matter. What their
Okay.
rental agreement is, it
Okay.
doesn't really
All right.
matter. The issue is, how much did they pay in rent?
Right. So
Okay,
Thank you, Your Honor.
sustained. That
we
is-
have no rental receipts from the landlord saying they paid $600 a month.
I'm very well aware of that. Again, you don't have to testify as to what's not there.
Okay.
Just testify as to facts and
Okay, then.
that you want to put in evidence that aren't in evidence. That comment is an argument.
Okay,
All right?
I'm done with that one. As far as the storage units go, as far as the storage units go, like we testified before, had sale went on, they rented these storage units before the contract in September. So we're not liable for September, October, and had
That's
that,
an argument.
okay.
It's an argument,
Excuse me.
not fact.
Excuse
Factual
me.
basis. Okay.
So, well, I'm just saying.
Testimony is what you know,
Okay.
or saw, or heard,
Yep.
or what exhibits you have that haven't been identified yet.
Okay.
But don't tell me what that means legally, because you're going to do that at the close of the case and closing argument.
Okay,
Okay?
all right, well, that's about it on that. Now, what else we got? The moving, there again, documents are not signed nor notarized. So I would say that's about all I got to testify at this time.
Now, if you wish to testify, remember you submitted exhibits, but they're not in evidence, so just you submitted so they would be noted for the record in the recording. So unless they're testified to, they're not part of the case.
So I submit them now?
Well, I haven't heard any testimony about them, so you're going to have to testify, get your exhibits, go through them, tell me what they are, and then we'll see if they're, after he questions you, whether they'll be admitted.
This is Exhibit A. This is.
Okay, and for purposes of record, anything that Mr. Bailey refers to will be Bailey, Defendant Bailey A. Go ahead.
This
Exhibit A?
A,
All right, go ahead and tell me what it is.
it's page 10 of the contract.
All right, page 10 of the contract, what lines?
Page 10,
At the top.
yeah, page 10.
At the line, at the top, there's a lines number, I think. Oh, I guess that's not, okay. All right, page 10, is that the last page of the
It
agreement?
is.
All right,
And page 1 also falls under that, under page 1.
under Exhibit A,
Yeah,
page 1 and page 10?
yep.
All right,
The addendums are B, and they number 1 through,
now yours are letters.
yeah, Defendant's Exhibit B.
What is that?
That's 1 through 4, I believe.
Addendum 1 through 4?
Yeah.
All right,
This one is C, that's pre-approval letter.
for plaintiffs?
Yep.
Okay,
And this is D. It's for the inspection. And I believe is their bills? Do I have to turn them in too?
No, their bills are in the exhibits they've marked.
Okay. All right.
Those have been admitted.
So.
Anything that's plaintiffs has been admitted.
Okay. So I should be done then.
You have anything else you want to testify to?
No.
All right. I'll let you ask questions first, and then him. So, since there's co-defendants, so do you have any questions you would like to ask Mr. Bailey, Mrs. Hagan?
I don't think so, Your Honor.
All right. Now, Mr. Ford, any questions?
Your Honor, we don't have any questions to ask. I will just raise my objections to the exhibits when they're at the end of the case.
Okay, well, when he moves to admit them then. Okay.
Yes.
All right. All right, you're not going to call any other witnesses?
No,
All right, you wish to have exhibits A through D admitted?
I do.
All right, now, your objection, Mr. Ford?
Yeah, if I can go through these exhibits, Your Honor. What
Let
I
me see
have,
them, if you would.
what I have and what I've been giving. Exhibit A, what I see as Exhibit A that Mr. Bailey has provided are pages 10 and then pages 1 of the original contract, and then a letter that was provided by a third party that.
Let's deal with them one at a time. Now, I have Exhibit A as being he said page 1 and page 10.
Right.
And I'm going to exclude those because it's already in evidence in
Okay.
Exhibit 1, so they're
We wouldn't
redundant.
object to those.
Okay.
Right, so that's redundant, and we don't need that.
Okay.
All right?
Okay, the third document I have that's exact one is a letter dated April 10th from Donald Fender. There's been no evidence regarding that. I would say that it's,
Okay, that's not marked. This letter from Defender, he didn't testify to that.
it was the third page.
Oh, it's the inspection letter. Is that what you call the inspection letter?
I think it's from the realtor stating that,
Your Honor, it was the third document.
plaintiffs never
Wait a
closed
minute,
on the
wait.
contract.
Okay, it was the third document?
In
Part of C?
in Exhibit A.
Oh, in Exhibit A.
Yeah.
All right, so this is part of Exhibit A.
Right, there hasn't been any authentication of that, and I would say that I would not admit that evidence.
I'll agree, it was not authenticated, so that's not admitted.
Okay, what I have as Exhibit B are addendums
Yes.
and a cover page, 2 addendums and a cover page. Well, actually, it is an addendum.
I just have 4 addenda, is all I have.
I have 3 addendum there.
I have
Oh,
8-6, 8-30,
Yeah, I have
9-8, 9-14.
2. I have 2 that are stuck together. We wouldn't object to any of those.
You do not?
No, not to
Okay,
the
so
addendum.
they're admitted. Okay.
Okay, what I have as Exhibit C is a letter that has not been verified and a check that has not been verified. And besides, I don't think it's
I
relevant.
believe he said it was the inspection letter.
I'm sorry?
He said it was the inspection letter, so he did testify
Well,
to what it
the
is.
inspection letter I have is Exhibit D.
Yeah, D, that's what I just said.
I was referring to Exhibit C. We would object to that.
Exhibit what, C?
C.
I thought you said you didn't.
No,
Oh, wait a minute, it's Exhibit C, I'm sorry, all right.
Yeah.
Exhibit C, that's the pre-approval letter.
Yeah, well, it's a pre-approval prior to, not to this contract. It's with a different contract, and it's also the payment that my client made for the earnest money, and that's not an issue here. So I would argue that this is not relevant.
Well, I'll admit it for whatever it's worth. It doesn't have a great deal of weight. I mean, I don't think there's any.
There's been no authentic-
There's no disagreement about it, so I'm going to admit it.
Okay, and the final Exhibit D is the
Inspection report, September 15.
right, from Hyman Engineering, that's at issue here, and it was received on the 15th. I wouldn't object to that.
All right.
I think we've already
So
introduced.
A is not admitted, B, D, C, and D are. Okay. All right.
Is this my copy?
No, these are the court's copies, so I'm just putting them there for the next witness,
Okay.
if there is one. All right.
No further objection.
All right, you may step down. And you're resting, Mr. Bailey?
Yep.
All right. Now, Ms. Hazard, it's your turn. Do you wish to testify?
No, Your Honor, I really don't think it'd do me any good.
Okay. And you're not going to present any other witnesses?
I thank you, though, for your patience and understanding.
Okay. Well, I had to get a little curt with you guys because I think
I
You know, the problem we have here is people watch TV and think that's the way courts work, and everybody's going crazy, and I just thought, you know, I need to put an end to this now, so maybe I was a little sterner than I needed to be, but since then, everybody's understood, and we've gotten along fine. All right, now, so you're not gonna put on any evidence, okay. You had a question, Mr. Van.
Yes, I did. It's not a question as much as a statement.
Well, I can't take any statements, okay?
Okay,
The evidence is.
that's good.
All right, so, now, do you have any rebuttal?
No, Your Honor, we would rest on it.
Okay, all right. So, now we're at closing argument. Now is the time for you to argue what things mean or don't mean. And so, Mr. Fork for the plaintiff goes first, then Mr. Bailey, you'll be able to argue, and then Ms. Hazard will be able to argue, and then they have the right to do the final rebuttal since they're the plaintiff. All right, so, Mr. Fork?
Okay, Your Honor, to start off with, very, very simply, this court has found that there has been a breach of contract, and the issue that is raised for review today is what are the damages caused by the actions from the breach of contract. And I think there's two parts to this. I've gone over those initially, but I think the first part is that there was a closing date of September 30th. The notification came from the VA, and the VA stated that based upon what they've received, they tentatively approved the contract, but it wouldn't be completely approved until they got a certification of the authority of Hyman Engineering. So that would be what Mr. Rogers what Mr. Bailey has marked as Exhibit D, and that would be the document. And they needed something from Hyman Engineering regarding their certification. And that was a condition. And that was something that the Rogers, acting through their realtor, requested, and it was denied. So that was a condition of the appraisal, Exhibit D. One of the conditions of the appraisal was that the VA was requiring, as part of that inspection of the housing, that they get certification from the engineering. And they didn't notify. The testimony from, I think, Ms. Pratt, and we've also had the testimony from Ms. Rogers, was that came at about 4:30 on Thursday, October 30th. So the earliest they could get it done was to send by overnight mail to the VA, and that would have taken an additional day. So that's why there was an extension made in 1 day. And the failure to agree to that extension was an interference in the inspection report made by the VA required that would be set forth under that they have to comply with that under paragraph 17 of the contract. And that's the same as the objections that this court has previously found. Now, there's one issue that does come up, and that is an assertion that Ms. Hazard has made that clients had 7 additional days to close, and they could have closed during those 7 additional days. Now, if you look, that's under paragraph 22 of the agreement. And what it specifically says in the contract is that that applies if the parties have been acting in good faith. Then they can go forward and have an additional 7 days. This court has already found that the defendants did not act in good faith, and that is their breach of contract and why everything was delayed. So those 7 days did not apply. If you look at paragraph 22, the 7 days do not apply. You have to comply with the agreed upon closing date, which is why Ms. Pratt testified that she created a document to get those additional days, because you had to have an addition of the closing days because that provision 22 didn't apply. And that's why all along, all of these that Mr. Bailey has brought up, and we've admitted to them because everybody worked out that agreement up until the 30th, and then they would refuse to do anything further. So we consider that to be a continuing breach of the contract recognized by the court previously, but now it would also apply on the 30th. So after that, my clients were unable to close, and they have come forward and they've set forth all of the damages that they incurred. We went through those in detail. I don't think I need to go through detail anymore, but they said that they testified what the rent was that they had to pay and the extra utilities they had to pay beginning on October 1st, which is the day that they could have moved into the contract or into the residence at issue in this case, but didn't and had to go move somewhere else. And up until, all those damages cut off on May when they were able to close and permanently move into the house that they ended up buying. But the expenses they had to pay for doing that and the expenses they had to pay for the rental, which they wouldn't have incurred if they had been allowed to move into this, were the total, I think it was $12,273.40. And we would assert that those are the damages that they have suffered from being delayed, from having to rent an additional house for 8 months and live there and move all their material out of the house they lived in Coleraine Township, Hamilton County, into a place before they could move it into the house where they live now. So that would be our itemization of damages. So in short, we believe that there's a complete breach of contract, including a breach of refusal to close on the 30th or to extend until the October 2nd, one business day, in order to complete that, to complete all the terms that the VA would have to approve the renovation loan. And second, the damages that were caused by their failure to grant that extension or to close on the contract. And that's what we would ask for damages, Your Honor. We'd ask for an extension of the breach of contract final order and to the effect of $12,273.40.
All right, Mr. Bailey, now's your chance to argue.
Yes, Your Honor. We'll start with the electric. You would have to pay electric no matter where you moved. You're going to pay electric bill regardless. So as far as the electric, it's not actual receipts from the electric company. It's a copy from a computer that's poorly printed that you really can't read all the dates. But I did read enough to where March is double charged, a fee of, I ain't got my glasses, $297.64. So the double charge on this account, it's not notarized, it's not official, and it's not even from the electric company as their original receipts. So, and as far as the water, I see no receipt or no paper charging on that bill. So what I guess I'm saying is, anybody could print this up, and it's not really proof of the electric bills. That's on that. Now, as far as the units rental, had they gone through with this sale, like I say, they wouldn't have had to rent 2 months worth of these rentals. My other point is, they moved into the residence that they live at now, which they bought. I wouldn't think they would have to have that storage. If you moved into a house, you wouldn't need a rental storage. Plus, nothing's signed, nothing is notarized. And the units and the lease, I guess we'll go to the lease. There again, if they had bought the place, they wouldn't have had to pay October, November, December rent. The rent really has no receipts from the owner, and there's no proof that the plaintiffs say they leased this, or they rented it for a while, then all of a sudden, right before court, they ended up buying it. There's no proof that they didn't buy it way back in December. So I would ask that this be disregarded. So that's pretty much, unless Kim's got something to say, pretty much all we have to say.
All right, Ms. Hazard, you wish to make any closing argument, you may do so.
Just that the 7-day extension, I don't know why they're objecting, that they had the 7-day extension according to the contract to close after the 30th to October the 7th. The extension, the last extension that was needed was because of a revised loan. They needed they jumped from Daryl seeing a lawyer all the way to September the 30th. You see, they act like there was no August and no days in between. And being as though he seen a lawyer, well, that held everything and that messed everything up. When it didn't really mess everything up, it just delayed it probably 2 weeks or something, but it didn't mess everything up. The VA still needed to do their sequence of inspections, whatever they were, whenever they needed to do it. They didn't know when, we didn't know when, it's just whenever they, and the last extension needed was for a revised loan, not due to no one letting people on the property to do their inspection or their appraisal. That was only in July. And I still state that they had until October the 7th. That's what the contract says. And it was a good faith after, he seen a lawyer. He was approved from our agent to go see a lawyer. So nobody never say, hey, no, you can't see a lawyer. She just said, okay, take time, I'll tell them. And there was lack of communication and whatever. That's probably main thing of the whole problem was everybody not communicating right or something. And that's pretty much all I have to say.
Thank you. Mr. Ford, do you have any
Yes.
rebuttal?
Yeah, Your Honor, in rebuttal. First of all, I'd like to address Ms. Hazard's argument, and then I'll address Mr. Bailey's. What Ms. Hazard is arguing is that your prior ruling that they acted in bad faith is incorrect. And she's saying that you were wrong in determining that there was bad faith and a breach of contract. I'll tell you, I don't believe that. There's clearly evidence, the stuff that you pointed to before, and it has never been objected to, because there was no response to our motion for summary judgment, that delays were caused by the defendants, by both Ms. Bailey and Ms. Hazard, refusing to comply with the conditions. And one of the, especially the conditions required under paragraph 17 of the contract. And that's what's at issue here. The VA required an engineering inspection, and as part of the condition of that, they needed to get the certification page from Hyman Engineering, and that was, they didn't make that request until 4:30 in the afternoon on the 28th. So in order to get that, there would have had to have been an extension of 1 day in order for the overnight mail to come through, and they refused that, and that would be a violation of 17. Also, the provision in 22, it does provide us 7 days. It's another thing that Ms. Hazard has argued. That only applies if the parties act in good faith. It says so directly in that portion of the paragraph. And this court has already found that there was no good faith acted, that in fact there was a violation of that, and that's why there is a breach of contract. So the additional time, if there was any additional time beyond the closing date set forth in the original contract were extended according to the provisions of that contract in writing and signed by both sides was September 30th. So there was no additional 7 days that were viable in that case. It had to take place on the 30th, or there had to be a written extension. And of course, that was not agreed to. That was a violation, and we think that that's a cause of all the additional damages that are asserted. Now, these were addressed by Ms. Rogers when she took the stand. She's gone through each item of evidence that she had. She has documentation for some, others she would just have to remember what it was and testify, but there's no evidence that any of her testimony was wrong. There's been no evidence presented here. There's strictly a situation of something like these weren't notarized, but none of that's a requirement. The question is whether Ms. Rogers told the truth when she identified all of the damages that they had occurred, both from having to move to a new house, having to get additional electric and water utilities, paying for the storage because they were only in a temporary position. And of course, what we have done is, even if, for example, even the time of the storage unit that they did, we're only counting the time when they had to use that storage unit to house the furniture when they had to move away from the residence they were living in at the time they got the contract, not if they had used it beforehand or they used it afterwards. In the total, it comes to $12,200 or $14,273.40. That's really uncontested in here. There's been no evidence that that wasn't the amount that they actually paid. She's testified clearly, and we would ask for a judgment on count 2. As I said before, you addressed earlier, counts 1 and count 3 we would dismiss, but we would say that we are entitled to those damages under count 2 of the complaint for the breach of contract, and the breach of contract was violation of paragraph 17, failure to comply with the VA restrictions. This was a VA loan, and it specifically says in the contract that they have to comply with the terms of the VA loan, and that's what they failed to do, including the extension for just 1 day beyond the 30th. So we would ask for a judgment in that matter.
All right, thank you. All right, I'm very familiar with the case from a ruling previously and on the law in this matter, and so I am prepared to rule. The original contract, the court has already found was breached when the defendants indicated that they were not going, that they did not want to sell. I think it was primarily Mr. Bailey indicated that, and then that it wasn't until there was negotiation about the shed and so forth that there was an agreement to extend the closing. I think originally to August 30, then to September 3rd. And there were some texts and so forth that confirmed that. So the court's ruling today is not based upon those matters, which are not introduced today, but upon the fact they were introduced in summary judgment. Now, so the court does find that the evidence is established that the defendant's breach of the original provisions did require the matter to be extended to September the 30th. And the court finds that the reason that the closing couldn't go forward was because of the VA's requirement to have the certifications that were testified to, and that would not be available until the following Monday, October 2nd. Paragraph 22, starting at line 418, sentence reads, notwithstanding anything to the contrary, in the event the buyer and seller are proceeding in good faith performance under this contract, and closing cannot occur due to occurrence or circumstances out of the direct control of either party, the date of closing shall be extended for a period of up to 7 calendar days. Unless otherwise agreed, such extension shall extend the terms of possession and occupancy by an equal number of days as closing was extended. So the court finds that the defendants did breach the addendum extending the time to September 30 and paragraph 22, line 418 to 422 that I've just indicated by refusing to go forward. Now, the fact that the plaintiff didn't show up for the closing, that's the reason why specific performance was not permitted, because there was never any tender of payment in full, and so that was the reason the court initially declined that, and then after the case was developed, plaintiffs have withdrawn that request. But nonetheless, there is a breach of contract. And damages, the court finds, turn to the damages as follows. First of all, with regard to the rental. The rental was $600 a month. Had they closed, they would have been paying $1,200 a month. So they did not suffer any loss during that period of time. In fact, they were saving $600 a month. So there's no damages for rent. For storage, the court does grant damages for that because of the uncertainty as to where they were going to be living. However, that will be from November 16, 2023 up until June the 1st when they close on their current residence. And that's at $261.07 per month. That is labeled as a receipt. She's authenticated it. It does not have to be notarized. It has to be it's a question of whether the court believes the testimony. I believe Mrs. Rogers' testimony that said that they did make those payments. There's no reason to believe otherwise. And so the court will award that according to and I'm going to go back and calculate this again, but I did some quick calculations here, and according to that, that means that possession would have been due the plaintiffs on 11/16/23 up through 6/1/24. So I'm counting that as 6.5 months at $261.07 per month. And my preliminary total is $1,696.96. And I'll confirm that when I write the decision later today. With regard to the moving expenses and U-Haul and so forth, I don't doubt the expenses were incurred. I believe that. But the problem I have is there's really no difference between what it would have cost to make the move to Hillsborough directly and how much is that extra because of the move to the storage unit and then to Vive. So that is speculative, so the court cannot find any damages for that. The same with labor. The court can't find that because the evidence doesn't explain what the difference is. It's kind of with the situation with the rent. What would it have been without the closing or with the closing? So I can't make any determination there. The same and for utilities, again, the defendant's point's well taken. There would have been utilities no matter what, and so the court will not order any damages for that. In terms of the increased cost of searching, Mrs. Rogers testified it was every bit of $500 for fuel, and then later I think indicated $750. While that's not documented, certainly the fact that they made numerous trips and looking at properties and so forth would mean the incurring of additional expenses, and the court finds that $750 is not an unreasonable amount. It's probably understated, quite honestly. I think Mr. Ford thought it was, but that was what she testified to. So the total damages to be awarded will be $1,696.96 plus $750 for the moving expenses. That preliminary total, I'll again total this to get the exact date, would be $2,446.96. So judgment is granted in favor of the plaintiff against the defendants jointly and severally. It means you're both liable for the full amount. Between each other, you're liable for half. But if one of you don't pay, the other one could be forced to pay the full amount and then try to collect from the other party. Also, the court costs will be ordered to be paid by the defendants jointly and severally. I'll prepare the entry and hopefully have that filed later today. And parties have 30 days from the filing of that entry to file an appeal if either of you wish to. Court will find this as a final appeal order that adjudicates all issues, and there's no just cause for delay. All right, anything further from Mr. Ford?
No, Your Honor.
Anything from defendants?
No.
I would just like to thank you for being patient and understanding.
All right, well, thank you.
Sorry about
You're
lack
okay.
of honor
You're okay.
because of lack
You're
of
okay. I understand it's
knowledge.
lack of knowledge,
Okay.
it's not, and so,
I do.
obviously, you did everything you could after that.
So our total caught fine is 24.28, more or less, give or take.
2,446.96. And again, I'll go back and make the final calculations with a
She
tape.
is responsible for half.
You're each responsible for half.
Gotcha.
But well, no, let me back up. Joint and several means this. You're each responsible for the full amount. Between the two of you, you're responsible to each other. And the reason for that is the law says they can't expect the plaintiff just to collect it from half from one and then have to go after the other.
Okay.
If the other doesn't pay their share, then they can get it all from either of you, and then the other one can turn around and sue the other for not paying their share. Okay?
Your
Thank
Honor, Your Honor, we have one other issue I'd like to raise. There was testimony here that the $500 earnest money is still being held by the agency.
Oh, okay, that will be ordered refunded to
And what we
plaintiffs.
would ask is, all that needs to be done is an order from the defendants that that be released, and then.
Well, I'll order it.
Well, yeah,
Yeah, I'll take care of it, won't it?
they have to go and release it, real estate.
Well, I'll do this. I'm going to order that the $500 earnest money be refunded, and that the defendants will sign any documents necessary to effect that. Who's
Okay.
holding that money?
Thank you, Your Honor.
Who is
Home
holding that?
Expert Realty,
Who is?
Home Expert Realty.
Okay, Mrs.
They're-
Pratt's realtor.
Yeah.
No, it's held by,
Although she's not with them anymore, I guess.
No.
right, but the name is, if you just
All right,
give me a
order.
second.
Isn't it
Home Experts
Yes, Home Expert
Realty, and where are they located?
They're located on Cincinnati Dayton Road. I'll give you the exact address here in just a second.
It's on the contract, isn't it?
I don't know if it's, yes, I believe it is on the contract.
Okay. I'll make that, I'll include that.
Okay, thank
All
you.
right, thank you. All right, this is case number 22 CR 185, State of Ohio versus Joshua K. Wrenchin. Are you Joshua K. Wrenchin?
Yes, sir.
All right, Wrenchin, you were indicted by the grand jury back on September 13th of 2022 for one count of aggravated possession of methamphetamine.
Yeah.
Alleges that on about March 17, 2022 in this county, you did knowingly obtain, possess, or use methamphetamine. That's a 5th degree felony, which if convicted, carries a possible prison term between 6 and 12 months, a fine of $2,500, and also a possible license suspension of 6 months to 5 years. Now, you are entitled to have an attorney to represent you in this matter, and if you do not have the funds to hire an attorney, the court will appoint one for you. Now, I see that you have filled out a financial disclosure form. Is everything on this form correct?
Yes, yeah.
All right. When's the last time you worked?
It's been a while. I had some medical problems last few years.
All right. Court then finds you are entitled to appointed counsel. I'm going to appoint attorney Catherine Hapner of Hillsborough, Ohio, to represent you. And in the absence of counsel, I'll enter a not guilty plea on your behalf. We'll set a bond review hearing for Wednesday, June the 19th.
I was hoping
Just be quiet, I'm talking.
Sorry.
That'll be set at 8:30 a.m., and that'll be a Zoom hearing. Set your first pre-trial for July the 10th. That'll be at 1 o'clock. Final pre-trial will be August 7th at 1 o'clock, and your trial will be set for August 29 at 8 a.m. All right, bond will be set in the amount of $2,500 plus your own recognizance, which is your promise to appear. And if you fail to appear, you could be prosecuted for an additional felony. And if convicted, sentenced on that, no matter what happens in this case. You'll also be under pretrial supervision of the probation department at 117 East Main Street. So if you do make bond, you're to report there immediately after your release. If it's after 4 o'clock when you're released, then you would report by noon the next business day in person. You're required to report to them once a week for 4 weeks, and after that, as they determine, undergo random drug testing they may order, provide phone numbers for home, cell, employer, if recommended by probation. You'll be evaluated for substance abuse or mental health issues. If any treatment's indicated, you enroll in and follow that during the pendency of this action. You'll also be under house arrest at your residence at 88 Cobbler Street.
That's not my address anymore.
Pardon me?
That's not my address anymore.
Okay, that's what you listed on your form. What's your address?
They filled the rest of it out for me. I had trouble remembering numbers. I had a brain aneurysm.
I can't understand you. What's your address now?
I live on Stryker Lane. It's off Colorado. That's what I'm saying. I had a brain aneurysm. And I had trouble remembering numbers. I thought they had it correct. I'm sorry, sir.
Where is it?
It's like 159 Stryker Lane.
All right. Well, wherever it is, you'll be under house arrest at that residence. Meaning you have to be at all times unless you're working, going to and from work, medical appointments, court proceedings, in this or any other case, appointments with an attorney in this or any other case. You can also attend schooling and kind of job training, educational programming of any sort, or church services. Other than that, you have to be there at all times. We'll notify your attorney of her appointment, and we'll have that hearing by Zoom Wednesday morning at 8:30. All right, do you have any questions, Mr. Rensham?
Yeah, I do. Is there any way we could do a quick bond hearing? Like, I'm
Pardon
trying
me?
to get, I don't have the money. My kid's at home and she's got special, like.
Well, you haven't, if you're homeless, that's not helping. And the
I'm
other
not
problem is
homeless.
that this indictment's over 2 years old. And so,
Yeah, I didn't know.
or almost 2 years old. So right now, that's going to be your bond. You can talk with your attorney, and after she's consulted with you, if you have some facts that would warrant the court reviewing that, then I'll certainly do it, and she'll bring it to my
I've never
attention.
missed a court.
All right?
I've never missed a hearing with you.
That's
sir.
it, Mr. If you have any questions, I'll answer your questions, but I'm not going to listen to you tell me why you need a bond. I've already ruled on that issue. Now, is there any do you have any questions?
I don't have the money to get a bond, sir.
I asked you if you had any questions. That's not a question. I know you don't have any money for a bond. Here's the problem. It took almost 2 years for you to be found, so that's why the court's not going to let you out, particularly when you tell me you're homeless. You have no job, you have no roots, so we're not going to just turn you loose. That's the end of that. Now, one more time, do you have any questions?
I've never missed a court hearing with you, sir, I promise you.
Okay, you don't have any more questions. Thank you.